All right, all right. It looks like we are live. There is no going back now. For those of you who do not know me, I am Boss Attorney Bri. I am a California licensed attorney where I practice family law and trademark law. And here on this channel, we cover celebrity lawsuits, trademark lawsuits, copyright lawsuits, really whatever type of lawsuits we feel like covering. So if you are new here, and you are interested in those or lawsuit topics, make sure you hit the subscribe button. And if you are here watching live or on the replay, make sure you go ahead and hit the thumbs up button to help the channel out in the algorithm. So today we are going to be getting back into the Johnny Depp versus Amber Heard defamation trial because, of course, Amber Heard is back at it again. But before we get into all of that, we are going to do a little update on a case that we covered last week. I don't know if you guys have seen in the media the coverage that has been going on. The Nipsey Hussle trial has finally come to a conclusion, and the jury has come up with a verdict for Mr. Eric Holder. If you guys do not remember that case, I'm pretty sure we covered it last week, if not the week before. And basically what happened is rapper Nipsey Hussle was unalived by this defendant, Eric Holder, where he basically shot him 9 times, or not 9 times, he shot at him about 9 times. And the defense in that case was that it was in the heat of passion. This should be considered a lesser charge of voluntary manslaughter, but the prosecution was going for actual murder. So I'm actually going to put up a poll. If you guys already seen the verdict, that is okay. Go ahead and vote in the poll. Let me know if you think that he should have gotten voluntary manslaughter. So remember, murder, it means that you had the intent to unalive that person. I'm trying to limit my wording so I don't get a yellow flag on my video this week or today. Murder is intentional unaliving. Voluntary manslaughter is basically that you were in the heat of passion. You didn't really have control over what you were doing. You were just so mad that you ended up harming this person and unaliving them. Now, the thing with his situation and claiming that he was still in the heat of passion, if you guys remember from the previous live stream, basically, he had 9 minutes to cool down. He left the scene. He had his fries. He loaded a gun. The girl that he was with told him to put the gun down. He decided to pick the gun back up after eating a couple of fries, according to the getaway driver. And then he proceeded to run around the building and then unalive Mr. Nipsey Hussle. So a lot of us on the stream said that there was no way that this can be considered heat of passion. He did too many things in between to change his mind. He should have not parked around the corner. He should have just left the scene. All of the things that he could have done in order to calm himself down out of the situation. And if you guys remember, the main thing that he was mad about was the fact that Nipsey Hussle called him a snitch. Words that he couldn't necessarily really confirm. So, like I said, I'm putting up a poll. We're putting up a poll to say what charge should Eric Holder, what is his name? Eric Holder get. Okay, and then I'm going to pop into the chat in a little bit here, but I just wanted to put this poll up and give a brief reminder of what was going on. We have voluntary manslaughter. I still might get a yellow flag on this video because the opening just started out a little aggressive, right? And then let's say he's not guilty. Okay? So we have manslaughter, guilty, and then murder, guilty, and then not guilty at all if you guys think that he should have gotten away with this. And remember, he couldn't really say he didn't do it because it was on camera. So let me know what you guys think he should have got. It's okay if you already seen the verdict. We're going to talk about what the verdict actually was. I'm just going to not say anything just in case some of you have not seen the verdict while you guys go ahead and vote. We have Cheryl here on the live. Hello and welcome to the live stream. Looked like you was early. I was a little bit late today, but not as late as the last few times. We have Tanya D always here to support, a moderator and member of the channel, saying hi to Cheryl. Welcome to the live stream, Tanya. We have Elena J saying hey y'all. Hey to you as well. We have Panda Bear popping in. Welcome to the live stream. We have Tanya D saying, Bri, just know I like you, girl, because these long ads are killing me slowly. So with the long ads, here's a hint. With the long ads, you just have to watch 30 seconds. If I'm the not for the skippable ones, you only have to watch 30 seconds. For the non-skippable ones, they're limited to 15 seconds, so you can watch those whole things. So that's a little trick that you can do with the longer ads. You just have to watch the 30 seconds of it, or click on it, or you can click on it. All right, we have Jennifer Miller, a moderator and member of the channel. Our first member of the channel saying, hey, Bri, and hey, Hive. Hello, and welcome back to the live stream. We have Miff Duffer saying, I have to watch a 3-minute ad for Domino's. I'll be there shortly. Like I said, guys, you can watch 30 seconds of those longer ads, but that is okay. I'm happy to have you here. We have Tanya saying hello to everyone. Can you guys comment while you're watching the ads? I did not know that. All right. We have Jennifer Miller saying, I'm cooking routine for dinner. So not going to be super chatty away. That is completely fine as long as you're here. We're happy to have you here. We have Cheryl waving again, and we have Tanya D saying, good to know about the ads. Yeah, you guys can 30 seconds, you're good. You don't have to watch the whole thing. All right, we have Sage Moon saying, hey, everybody, so happy to be listening in on another Bri Hive Live. Yes, welcome in, Sage Moon. Nice to have you here. And we have Ryan Blackhawk saying, howdy. I pay for YouTube Premium for the family. That also contributes to the channel as well. So YouTube Premium, it's some type of percentage. So thank you and happy to have you here. So I'm going to go ahead and check out the poll. See, we got a couple of votes. If we can get 5 more votes, if you guys haven't voted on the poll yet, then that might be a little bit better. It's a little surprising. I was not expecting this result, but we have the result. So let's check it out. Okay, we got a couple more votes that just came in, and it's only been up for 2 minutes. So let me go ahead and leave it up for like 3 more minutes to see if we can get some more votes on the poll. Remember, this is in the Nipsey Hussle trial where the guy unalived the rapper Nipsey Hussle. But before he did it, he basically got in an argument with Nipsey Hussle. He left. He went around the corner. He loaded a gun. He put the gun down. He ate some fries. Then he came running back around the corner on foot, shot Nipsey Hussle, and then ran back to the car and left. Do you think that that should be considered during a heat of passion? 9 minutes passed, guys. This was not a 1-minute situation. This was a 9-minute situation. Do you think that he formed the intent for murder? So, all right, we got a couple more votes coming in, and let's see what the peoples are saying. Panda Bear says, this is way better than having to go to the ER 3 times in the last few days. Well, I am happy that you're not in the ER, and I'm happy that you are joining us here live and having some fun, right? We have Ryan saying, oh man, I want some poutine. Oh, what is poutine? And we're traveling to Canada tomorrow. Well, have a safe trip going out to Canada. We have Amy Greenberg saying, good evening, everyone. Welcome, and good evening to you as well. And we have Tanya just giving the welcomes to the stream as usual. Okay, so I think we got some good votes coming in at this point. Not quite 5 minutes yet, but over the vote count that I was waiting for. So I'm going to go ahead and read it off. We are determining what charge Mr. Eric Holder should have gotten. He is the person that shot Nipsey Hussle, and the options was voluntary manslaughter, meaning that it was in the heat of passion. The other option is straight up murder. And then the other option is not guilty. He should not have been held guilty. We have 18 votes in, so about half of the people watching the live stream. So I think it's a good time to go ahead and let you guys know what the chat thinks anonymously. So we have 22% for the voluntary manslaughter, thinking that this could have been considered the heat of passion. If you put voluntary manslaughter and you want to explain your reasoning, go ahead and drop it in the comment section below. Then we have 72% thinking guilty of murder. Actual intent was formed when he did this, which is what I thought a lot of people would vote for. It was 100% for a while. Oh, it just changed. We have voluntary manslaughter at 21 and then murder at 74. And then we have 5% saying not guilty. Someone thinks, or some people think, that he should not have been charged with anything in connection with this murder. And so it just kind of evened out a little bit more. We're at 75% for the intent. We are at 20% for the heat of passion and 5% for not guilty. So still about the same, but a little bit change since I read off the answers. So yeah, that is an interesting outcome, but that's what happens. Everyone's different. Everyone's going to believe different things. So super excited to see what you guys think. If you want to share why you put the answer, go ahead and drop it in the chat. And then after we do that, of course, we're going to jump into the nonsense that is Amber Heard. In my opinion, allegedly. Okay, so we have Panda Bear saying it's like gravy, isn't it? Speaking about the poutine from Jennifer. We have Tanya D says, just looked up the verdict. My cousin did something similar and got a similar verdict. Okay, so it seems to be pretty consistent. I wonder if it's in the same area. Ryan Blackhawk says, poutine dish of French fries and cheese curds topped with brown gravy. I have never heard of that. Sounds yummy, though. Kids are going to be eating good at Jennifer's house. Okay, we have Ryan saying, I assume this is someone different than the previous U.S. AG. As far as the person prosecuting the case, the United States Attorney General. No, this would have been a prosecutor in what do you call it? California. So Panda Bear says, sounds so yummy. Betsy, welcome back to the live stream, dropping the emojis and showing the love. We have Helena saying, I'll say it, murder under the law as it's described, it fits. So we believe that the intent was formed. A lot of people agreed with that while we did the stream the other day. So that's not surprising that we have more people agreeing with us today. We have Sage Moon saying, thank you. Oh, you guys are welcoming each other into the Bri Hive party. Welcome, everybody. Ryan says, okay, I want to change my not guilty. Okay, you might have missed the last live stream where we went through all the details from the testimony that we could find online. And we have Ryan saying, I did my answer because I did not know enough about the case. Yep, that's okay. We're just here having fun. We're going to say, Tiny D says, no, my cousin is in St. Louis. Okay, so still pretty consistent, even though it's pretty far away. And we have Panda Bear saying, feeling like my prediction is off on the verdict. Yeah, so he was actually found guilty of the full-on intent to kill. And so we don't know what he's going to be sentenced to yet. Probably life for being convicted of intent to kill, of murder, right? So we'll see what the jury comes up with for his sentence, but we could probably assume it's going to be something, if it's not life, then something up to life, right? For the full on intent to murder. Okay, let's stop using that language now. And hopefully we don't yellow flag. I can't see if I'm yellow flagged just yet. So, yeah, I don't know, but hopefully I'm not. All right. So we are jumping into the craziness that is the Johnny Depp versus Amber Heard trial. If you guys found me from that case, which I know a lot of people came over from Legal Bites, which I helped cover on her channel and some other channels while the Johnny Depp trial is going on. And to me, it's just so crazy that this is still going on. It was already a 1.5 month long trial, if not longer, because that week break. So we're looking more towards 2 month long trial. And now we are dealing with Miss Amber Heard, not yet appealing, but filing her post-trial motion. So she has some problems with the verdict that the jury came up with. And she's also accusing like some improperness within a juror. Like they were supposed to report something. So we're going to get into it. I didn't have time to do a PowerPoint. I know it's been forever since I did a PowerPoint, but I do like to do them, especially for something this long. It's a 53-page document. So of course, we're not going to be reading all of the words, but we're going to be jumping around, just looking at what are her arguments? Why is she bringing this up? What is she hoping to gain from this? So let's go ahead and check it out. Let's share the screen here. Find the buttons. All right. So for those of you who do not know about the trial, basically Johnny Depp sued Amber Heard, his ex-wife, for defamation for basically saying that she was a DV survivor and that he SA'd her. He was able to prove that those statements were lies, and he was able to win $10 million in compensatory damages. And then they awarded him $5 million in punitive damages, but then it was reduced down to the Virginia statutory limit, which was $350,000. So altogether, he won $10,350,000. Amber counterclaimed, sued him as well for defamation based off statements that his attorney made about her basically lying about the situation and basically creating what he called a hoax to stage like an altercation, which the police came to, and all of those things. And she was actually awarded $2 million. The jury basically found that one of the statements weren't completely true. I still don't see how they found malice, but they did. So that's basically the rundown of the case, or the rundown of the case for those of you that have forgot, because this case has been over for, I believe, over a month. So I don't know. All right. So let's go ahead and get the, not I don't know, but it's a rundown, right? All right. So we're going to go ahead and check out the case here. We have the defendant, Amber Heard, and she's the plaintiff on her counterclaims, stating, defendant and counterclaim plaintiff Amber Laura Heard hereby moves this court to set aside the jury's verdict, so she doesn't want to owe him money anymore, on all three counts of plaintiff and counterclaim defendant Johnny C. Depp complaint, to dismiss the complaint. So she wants to throw out the whole lawsuit as well, and to investigate improper juror service. What do you guys think about that so far? She wants to get rid of the damages. She wants to basically throw out Johnny Depp's claims after this 2-month trial. She wants to throw out the claims altogether. And then she also wants to investigate the juror, one of the jurors, right? So let me know what you guys think about that. And then we're going to just kind of pop on down to some of the, or we're going to go to the table of contents, because we're going to do an overview of what she's actually alleging. So one of her arguments is that the damages awarded by the jury are unsupported by the evidence and the law. And so that is why she's basically asking to throw out the $10,350,000, because it's unsupported. What is her reasoning? One of the reasons, there is no evidence of pecuniary damages from the op-ed, basically saying that any damages that Johnny Depp suffered did not stem from the op-ed, and since he sued on the basis of the op-ed, it does need to come from that situation. The jury, the other thing, or another reason, is the jury's compensation and punitive damage awards were excessive as a matter of law. We're going to get into this. She's basically saying that what the jury awarded was just too much for what Johnny Depp brought as evidence, right? Another reason why she is saying the jury award should be overturned is that Mr. Depp is not entitled to damages for any conduct prior to the op-ed. And we're going to get into that. She's basically alleging that some of the damages that she believed that the jury awarded was based on things that happened before the 2018 op-ed. We're going to get into some arguments in just a moment once we go down this these documents. Like I said, it's a long document, so we got a long way to go. Let me zoom in because I forgot to do that today. All right, fourth reason why she's saying the jury verdict should be overturned is Mr. Depp is not entitled to damages for alternative causes, including the Sun publication, the ensuing litigation brought by Mr. Depp, the UK trial and surrounding publicity, and the UK judgment. She's basically saying some of the damages that Johnny Depp is alleging actually came from the UK trial, that Johnny Depp is the one that actually filed the trial or filed for that trial. So another thing, like I said, we're going to get into a lot of this. And then the last reason why she is saying that the jury verdict should be overturned is because, or under this provision, actually, she has another one. Virginia case law supports setting aside damages judgments that are excessive. Basically saying that the jury awarded Johnny Depp too much for what he actually brought as evidence. So let's go on to the next reason why she's bringing this post-trial motion. Remember, this is coming from all of those objections that they were doing during the trial. Remember, objection. They're bringing those things in these post-motion trials. I don't know if she's put her bond up yet in order to fully appeal yet. I don't know. All right. So we have the next reason why she's going after Johnny Depp is the verdict on the complaint and counterclaims are inconsistent and therefore should be set aside. Basically saying that the jury messed up. They ruled one way on something and then inconsistently ruled another way on something else. Next thing of why she's saying that this case just needs to be thrown out is the First Amendment bars recovery for defamation by implication when the statements at issue are true on their face and involve public figures or matters of public concern. And if you guys remember, we kind of covered this in the Meghan Markle case when Meghan Markle was going against her sister, saying that the statements are true on their face. So the impact of the statement is still the same. It's still true, but maybe she missed a couple of facts in there that could have made it a little bit more true, is basically what she's saying. All right. And then we have the jury's finding of defamation by implication with respect to the op-ed headline statement is contrary to the law and unsupported by the facts. I honestly didn't get that far into my skimming, so I don't know what her reasoning is there, but we're going to look at it, all right? She's going to give us some of her reasoning. There is no support for the conclusion that Ms. Heard initially made or published the headline. The newspaper added the headline, and Ms. Heard played no role in authoring or publication of the headline. So not taking responsibility for whatever the publisher named the article. But she still made statements consistent with the name of the article. So I don't know. I don't know how strong of an argument that is going to be. But just from my skimming, a lot of the arguments that she put in there anyways are not very strong to begin with. So that's a whole nother thing, right? Okay, so let's go back to this thing here. All right. Another reason why she thinks it should be thrown out, she says Mr. Depp did not present evidence of actual malice. Present evidence of actual malice. The evidence that he presented was that she knew that she was not a survivor. But we'll see what their argument is when we get there. Okay, another reason why she wants it thrown out is Mr. Depp did not present sufficient evidence to support a finding of defamation by innuendo. Reasoning. No evidence surrounding the op-ed's publication would reasonably cause a reader to believe the title of the online edition is about Mr. Depp. She's going to stick to this. And we got Miss Elaine Bredehoff as the lead on this this argument or this motion, right? Another reason, no evidence established the contemporaneous facts surrounding the publication of the op-ed that would reasonably cause a reader to understand any of the statements as conveying a defamatory implication about Mr. Depp. Basically saying that no one can determine that these statements were about Johnny Depp. I don't know. Oh, I didn't skim that far, so I'm interested in seeing what the arguments are. Mr. Depp cannot recover for statements Ms. Heard made during judicial proceedings, and he failed to prove that any statement in the op-ed implies he abused Ms. Heard. You say that, but a reasonable person can infer that was about Mr. Depp. And you presented a bunch of arguments saying that it was about Mr. Depp. And if I'm not mistaken, I'm pretty sure Amber Heard said that Depp abused her and it was about him. So arguing that this was not about him is a waste of time and space at this point, because you have already admitted that it was about him. And if I recall correctly, and you gave evidence that he did, or your evidence, your testimony that he actually did abuse you. So how are you going to say that it wasn't about him? Who is it about then? Why did we just have a 2-month long trial if it wasn't about him to begin with? She wouldn't have been on the stand for 4 or 5 days if it wasn't about him. Okay, moving on. That kind of flustered me there. The court should conduct an investigation of juror number 15 and whether jury service was proper and due process was protected. All right, and then they're going to go ahead and get into the conclusion of the stuff. As you can see, they cited a lot of case law. Are they all accurate? Maybe not, but that's okay. We're going to let them have it. I'm going to jump into the chat, see what the peeps are saying. If you guys have not already done so yet, make sure you hit the thumbs up button. It will help the video out in the algorithm. If you're not subscribed, go ahead and hit the subscribe button. I have been on my way going up and down in the 7,970s for the last month. So if you guys are not subscribed, double check, make sure you're subscribed. Hit the subscribe button because we have been trying to get to 8,000 for the longest. Also, we do have memberships available on the channel, and when we hit 25 members, we are going to do a special live stream. So if you are interested in that, make sure you do all the YouTube things that you want to do or that you can do. All right, so let's see what the chat is saying here. Oh, and we also have super chats. So, not needed, but always welcome. All right, we have Tanya D saying she's trying to retry her case. I know Judge A is tired of her foolishness. Hey, I agree with you there. I think a lot of people saw right through it. I think we all understood that she was going to be bringing these motions, these appeals, trying to get everything thrown out, because she is still, I was reading some of this and she's still saying she's a survivor, but then again, arguing that it was not about Johnny Depp. So I don't know. I don't know her motive in this. Is it the only thing keeping her relevant right now? Who knows her point? But you're right. The judge probably not having a good time. I wouldn't be surprised if she retires after this. Amber Heard made me retire. My opinions only, right? Okay, McGruffy says, it'd be interesting to see what her legal team would look like, because Rottenborn and Brenna Hoff would not come back, in my opinion. Oh, they're the ones bringing this motion. So do you mean like that their firm wouldn't let them come back to argue the trial again? That would be such a waste of money to go through this again. That would be such a waste of money. But I think Johnny Depp has already proved his point. He got his story out there. I wouldn't even relitigate it with her at this point. That's so much money. Okay. Jennifer Miller says, I'm wondering if there's an appeal, does she have to use the same lawyers or can she hire a new team? Depending on whether a judge will find it to be too complicated to basically bring in new lawyers this deep into the situation, could consider it something new because it's an appeal, but also going through all the evidence from the trial and also taking on the other lawyers' mistakes. She probably wouldn't get a new legal team for the appeal. They're going to keep arguing these same things, I think, for her. Cal says, coming from the girl who countersued for $100 million because Johnny sued her for $50 million. That is one of the points that I wanted to make. She is saying that the award is excessive, but he sued for $50 million and she sued for $100 million. And he was only granted $10 million. So I don't think that's excessive as compared to the amount that they asked for. And now the amount that they ask for does not necessarily mean that, okay, that's how much they're going to get. But it's reasonable that he would get in the millions of dollars as a celebrity, as saying that he lost $40 million, as saying, or that he's a celebrity and his reputation was harmed. a bunch of different reasons why he could get $10 million. I don't see where they're getting the excessive argument. I skimmed through it a little bit. We're going to get into what they're saying is excessive and what they're comparing it to. It doesn't line up to me, but maybe you guys will have a different opinion. All right, we have McGuffer saying, Jennifer Miller, I wonder the same thing, but I feel like she should be able to change. What if one of her lawyers retired before the trial? Hypothetical. Yeah, like I said, it's possible, but really, who's going to take on this case? That would be the question. Ryan says, you are responsible for anything that goes out under your name. Yes, you actually are. Ryan Blackheart, and I think that's referring to the fact that she wrote the article and then they based the title off of what she basically said, right? Ryan says, I was communications director for a nonprofit and we hashed out everything, including headlines before publication. And it was out there and she still retweeted it. So, I mean, it is what it is. Tanya D says, watching Emily D. Baker the other day and looking at Amber Heard's tweet, she did not just retweet the article, she created an original tweet. Yeah, I missed it. I saw that she went live about this the other day, but I haven't looked at hers yet. I watched Andrea's because hers was a little shorter. Ryan says she admitted to it more than once on the stand and again in the interview she did with Savannah Guthrie. She's saying it in this motion that he abused her. So you can't turn around and say, oh, it wasn't about him. But yeah, he actually did abuse me. But it wasn't about him. But during that time, he actually did do those things to me. But not him. It must have been my other husband. I don't know. All right, Brenda says, yes, she did. McGuffer says, if anyone, Amber Heard should sue the ACLU defamation lawyer. He clearly didn't do his job. Tanya says, yes, we need to get Bri Hive to 8K. Yes, we do. Thank you so much. We have Jennifer Miller saying, we should talk to some of the other law tubers and do a new subscriber party. Get Bri over 10K. Yeah, everyone's been super busy lately. So I know it hasn't been a lot of collaborations on LawTube, at least that I've seen, because I've been working crazy in my law firm. So really the only time I have to get on LawTube or to get on YouTube is during my scheduled times, which is Tuesdays and Thursdays at 4 p.m. I might push it back a little bit later to 5 p.m. Pacific Standard Time, just because, like I said, my law firm is getting crazy busy. But yeah, when I have time or when they have time, super happy to do a collaboration with the law tubers. Okay, JRL says Amber needs to effing stop with this BS. She lost. Move on. That is my philosophy as well on this case. Honestly, even though I do a little bit of litigation, I took a test. I don't know if I talked about this on YouTube before, but I basically took a test in law school that told me that I was not a risk taker. And you are absolutely right. I'm not going to spend a lot of money to argue with you over nothing. Now, my clients may spend a lot of money to argue with their partners or the other parents in their family or whatever over nothing, because it seems a little bit more important to them. And I do get like kids are important, money is important, all of the things. But sometimes it's just like, the stress and the money of it, I'm not going to argue with you over you saying that I was abusing you. And as long as I'm not going to jail, I'm not going to spend $10 million to argue this for you. So, but like I said, Johnny Depp got his story out there. I wouldn't, if she appeals it, I'll be like, okay, whatever, you can appeal it, but everyone already knows and everyone saw you on the stand and everyone thinks that you're a liar anyway. So who cares if you get it overturned, right? McGuffer says, not Elaine. I don't think Bredehoff would want to try it again. And Rottenborg isn't with their firm. He left? His name is on this paper, and this was just on July 1st. Isn't with their firm. I think he got attached through Roberta Kaplan. Okay, now I gotta see. I thought they were in the same firm. Okay, we have Benjamin Rottenborn. Oh, yeah, they are two different firms. We have Elaine is in the law firm of Charlson, Bredehoff, Cohen, Brown, and Nedohoff. Oh, I thought you guys were spelling that wrong, but it's actually one of their last names. I didn't even realize that. And then Rottenborn is with Woods Roger PLC. So they could potentially drop out of there. But yeah, they do have two different law firms. I did not realize that. Okay. Let me get back to where we were in the article, not the article, in the motion, because we got to get into some of these things. So I'm going to go through the summary of the argument, and then we're going to skip around into some of the arguments just to kind of see what's going on there. Like I said, it's too long for us to go over on this live stream. You know, we try to keep it under 2 hours over here. We don't like to live stream all day like some other law tubers. So let's go ahead and check out the what do you call it here? The summary. So here we go. From the beginning, Mr. Depp set out to try this case as a domestic relations dispute he wished he had tried rather than settle in 2016. Oh, they are starting off strong, calling him out. Mr. Depp's counsel argued throughout the trial that the issues before the jury began 6 years ago, when Ms. Heard obtained a domestic violence temporary restraining order against Mr. Depp on May 27, 2016. I don't agree with that, just because the op-ed was technically based on that DVRO, DVTRO, because it was temporary. It was based on that. So they had to bring that up to show that the statements were about Johnny Depp. I don't think that they were arguing that the restraining order is what damaged him. So that's my little 2 cents on there. We have Mr. Depp and his legal team told the jury they were seeking to restore Mr. Depp's reputation and his legacy for his children, that this was the first time Mr. Depp has been able to tell his story since Ms. Heard obtained the DVTRO. I don't like that T in the middle. I'm just going to say DVRO, temporary DVRO, in 2016. The claims in this case were far different than the claims Mr. Depp tried to the jury. Mr. Depp's claims arose from an op-ed published in the Washington Post on December 18, 2018. 2.5 years later, Mr. Depp alleged that the 3 statements, one, the title authored the Washington Post, formed the basis of his defamation claims. To avoid explaining to the jury the UK final judgment finding Mr. Depp had committed 12 acts of domestic violence, including SA. They did the exhibits. Mr. Depp represented to the court he would limit his damages claim to the period between December 2018 and November 2020. The date of the UK judgment. Yet Mr. Depp made no such effort at any point in the trial to so limit his claim to damages. Instead, throughout even the closing, Mr. Depp continued to urge the jury to restore his reputation and legacy to his children as a result of Ms. Heard accusing Depp in May 2016. But that goes to what was actually published in the op-ed. She said during that time is when she was abused, and that proves her abuse. She's a DV survivor because she got a DV restraining order against him. I rest my case. The jury verdict was obviously influenced by Mr. Depp's pleas in the face of the court's preclusion of Ms. Heard from introducing evidence that Mr. Depp had already in fact been adjudicated in the court of his choosing to have committed not just one act of domestic abuse, all that was needed in the case for a defense verdict, but 12 acts of DV, including SA. The exclusion of the UK judgment, coupled with Depp's continuous urging to the jury to go back 6 years and exonerate him and restore his reputation, resulted in an indefensible $10 million compensatory damage verdict and $5 million punitive damage verdict. The verdict is excessive in the matter of law in light of the evidence of law. I didn't watch the whole trial, but I do not remember him saying that or doing that or like harping on the 6 years ago. What I got from the 6 years ago was that was the basis of Amber Heard's claim that she was a DV survivor because she was able to get the restraining order. Let me know if you guys got the same feels from it as she's trying to explain here. We know what an exaggerator our girl is, but that's okay. That's okay. Let me know if you guys got that 6 years ago. Do you think he rested it on that 2016 DVTRO, or was that the basis of her claims in the op-ed? I think it's the basis of the claim in the op-ed. Let's see what the peeps are saying here. JRL says, if I had Twitter or Instagram, I would tell Amber to cut the BS. She lost. Move on with her life. Yeah, I mean, it's a way to stay relevant, I guess. I don't know. We have Ryan saying, if she can't afford to pay Johnny Depp, how is she going to post an appeal bond for the full judgment and attorney costs? You would have a better guess than me, but apparently she had enough money to pay lawyers to write this 53-page document. So just give him his money, but she doesn't want to be known as being, defamatory to Johnny Depp. She wants to be known as a DB survivor. Dab says she ain't got no money. I bet Elon is still sponsoring her. Well, he didn't spend a lot of money on this trial if he is. Ryan says Nettlehoff was the third lawyer. Yeah, I did not keep up with all the names. Silva says the mini McGuffrey says the mini rotten porn. Okay, now that's ringing a bell. Definitely did not know his name. Daz Beat says, hey, welcome into the live stream. Yes, love to have the peeps here. Ryan says, like Emily D. Baker. Tiny D says, I rest my case. Yeah, exactly. I rest my case. I don't know what she's arguing. Let me see if I want to go through her whole introduction because it's long. Nope, we're not going through this whole introduction. We're going to go ahead and, well, I guess let's do it because it's going to summarize and we're going to jump around a little later on. So let's summarize the whole thing and then we'll jump around in the more detail a little later on. We have Jennifer saying, I watched the whole trial. I think the jury got the verdict right, but maybe the money could have been different. And the thing that's hard about saying that the jury's verdict was excessive is that the jury sheet only had a section of how much money they're awarding. It didn't say why they're awarding that much money. They just said, okay, she's not guilty, but she's liable. And she owes this much money. They didn't say, okay, this much money for losing Pirates, this much money for not getting other movie roles, this much money for damage to reputation. They didn't break it down like that. It literally just said 10 million, 5 million, for hers, just 2 million. And if it's, in my opinion, they probably left hers blank, and that's why they had to go back to the deliberation room. They probably left it blank. They could have ordered her less than 2 million. I think they got her money wrong for sure. Jennifer says Elon doesn't pay for his kids. He's not funding. Come on, Elon, you gotta pay for the kids. Pay for the kids. All right, let's go back into this here. Okay, further evidencing the confusion resulting from Mr. Depp's effort to relitigate the 2016 domestic violence relation matter without the truth of the UK judgment. The jury's dueling verdicts are inconsistent and irreconcilable. The finding of defamation against Ms. Heard with a $2 million award is inconsistent with the finding of defamation against Mr. Depp with a $15 million award. In the face of these inconsistent verdicts, the judgment should be set aside and a new trial ordered. And so that's consistent with what a lot of LawTube was saying, like how could it be a consistent verdict? But what she was found to be, what she won on was the description that Johnny lawyer gave about how the how the hoax was performed. Because remember, they found that she did do a hoax. They found that that was not false, but they said the manner in which she portrayed it to the public, all the description in there, that was false. So I don't know. I don't think she has a strong case on that one. At trial, Mr. Depp proceeded solely on defamation by implication theory, abandoning any claims that Ms. Heard's statement were actually false. But whereas here, the statements are true on their face, which Mr. Depp never challenged. The plaintiff is a public figure, which Mr. Depp has conceded he is, and the subject matter of the op-ed is on matters of public concern, which this court earlier determined as a matter of law. The First Amendment prohibits claims by implication. While this appears to be the case of first impression in Virginia, dicta in our courts and holding in our other courts is similar circumstances warrant applying. This is a lot of words. Set aside the judgment. They're saying it warrants setting aside the judgment. That's what she's trying to say there. Okay. Mr. Depp never challenged the fact that Ms. Heard did not write the title of the op-ed, and you obviously didn't argue it good enough, or else a jury could have found differently. One of the three of the defamatory statements comprising of Mr. Depp's defamation claims. Instead, Mr. Depp contended Ms. Heard's tweet of a link to an article the following day constituted actionable republication. In addition to establishing dangerous precedent, suggests that anyone retweeting or retweeting an article or link can be independently liable for its content. But she was also interviewed for that content. The interpretation is beyond the reach of Virginia law on republication because nothing in Ms. Heard's tweet constituted a legally enforceable republication. Typo. Oh, no, it's not. Me misreading. Okay, this count should be dismissed since the damage award does not separate out three separate statements. In the event the court does not dismiss all three counts, the judgment should be set aside and a new trial ordered. They're really trying to get this new trial. For the jury to find Ms. Heard demonstrated actual malice, Mr. Depp was required to establish at the time the op-ed was published, Ms. Heard did not believe she had been abused or that she had doubts about whether she was abused. But Mr. Depp presented no evidence that Ms. Heard did not believe she was abused. Instead, the evidence overwhelmingly supported Ms. Heard believed she was a victim of abuse at the hands of Depp. Okay, that's fine that she believed that she was a victim at the words of Depp. However, the jury did not believe that she actually believed that she was a victim at the hands of Depp. We talked about this a little bit on some of the other LawTube channels. Like, maybe she really did believe it, but her acting on the stand, in my opinion, was so bad that I don't think a jury even believed that she believed the words that were coming out of her mouth. So I don't know. That's a whole nother story. So she could have believed in her mind, but is she a reasonable person? That might have been the question that the jury were asking themselves. All right. But Mr. Depp presented no evidence that Ms. Heard did not believe she was abused. Instead, the evidence overwhelmingly supported Ms. Heard believed she was the victim of abuse at the hands of Depp. Therefore, Mr. Depp did not meet the legal requirements for actual malice, and the verdict should be set aside. Actual malice is probably because the jury thought she was lying and that she knew she was lying. Next, Mr. Depp improperly relied on time-barred judicially privileged statement as the basis of his defamation by innuendo claims. Although actionable innuendo must be drawn from the four corners of the documents in this case, it could only be drawn from the inference in the article to Ms. Heard's obtaining the DVTRO against Mr. Depp in 2016. This warrants setting aside the verdict on all three defamation counts. Yeah, okay, I see what they're saying there, but at the same time, even if he didn't go back to that DVTRO, she still said that he abused her, putting him into the four corners of the document. Now, we can all assume that it was based off of her getting the DVTRO, but she also then confirms it's about Johnny Depp by saying that he abused her, not only in the UK trial, but in this trial as well. So, I don't know about y'all, but some of her arguments are kind of counterproductive, if you ask me. If you want to know what I think, right? Okay. Next, Mr. Depp improperly relied. Oh, we already covered that, huh? Okay. Finally, the information on the jury panel list appears to be inconsistent with the identity and demographic of one of the jurors. So they're saying someone snuck in. Juror number 15 was apparently born in 1970. not 1945. That is a big gap. Who was juror number 15 that you confused 35, or how many years is that? That would be 25 years, right? Trying to do math in my head, lawyer math. As reported to and relied upon by the parties, including Ms. Heard, in selecting the jury panel. Does someone's age really matter that bad? I don't know. Given the requirements for, so she thought that he was born in, or that they were born in 1945, so that they would probably be more favorable to the woman in the situation. Is that what, was that her thinking? Given the requirements for verification of each juror, it appears the identity of the juror was not verified. It is unclear if juror number 15 was in fact ever summoned for jury duty. That would be messed up if they just kind of squeezed in there and was like, I'm going to be a juror today. I can see why she would be upset for that. Or qualified to serve on the panel. This warrants an investigation by the court to determine if the juror was in fact summoned or whether the due process rights of the parties were bypassed. Depending upon the results of the investigation, this may justify setting aside the verdict in its entirety and setting this matter for a new trial. So that is interesting to me. I was not expecting for the jury. Like I said, I just skimmed like the beginning of this document. I didn't go into too much detail. But what I thought they were going to be alleging that the jury did was to be influenced by outside factors. But they're saying this juror lied about their age, and they don't know if this juror was even actually summoned. They might have just said, hey, there's a jury pool going on. Let me just show up. And try to get on the case is basically what they're insinuating. So that's an interesting argument. That is an interesting argument. Okay, let me see what some of the chat has to say. We have Kath, welcome to the live stream, saying the media silenced his voice. That's why we're here. Even with the UK case, it felt like his voice was still silenced. Yeah, because they wouldn't let him testify to certain things, right? We have Daz B saying, is she using the same lawyers? Yes, she is. It's the same lawyers that argued her case in front of the judge. Jennifer Miller says, this reminds me of what my high school English teacher used to say. Poor planning on your part does not constitute an emergency on my part. That's a good saying. Poor lawyering does not constitute an appeal. Yes, that can go together. You are absolutely right. We have McGuffer saying the whole request sound like they're saying they want to retry the case the way Rottenborn wanted to do it in the first place. Yeah, I definitely see. Yeah, I can see that. I can see that for sure. Tanya D says, right, I think she may have won if her case was presented differently. She had to be extra. Yeah, exactly. The fact that she put on all the tears, on all the witnesses that wouldn't show up for her, like it just made her see the fact that she was on the stand for 4 or 5 days. I would not have put her on the stand that long because the jury did not like her. Okay. McGuffer says, my dog stepped on a bee. Justice for the bee. We'll see if we can get the bee justice and the dog too, right? Tanya D says, I just like a bunch of TikToks just popped in my head. Tanya D says, who would want to sneak in to jury duty? To see Johnny Depp every day? According to Amber Heard, this person that was born in 1970, they wanted to sneak onto the jury. As long as that trial was, I don't know if it's worth it. Okay, McGuffer says, what up, y'all? So when juror 15 got to court, no one thought to question why they looked 25 years younger. Amicus Green, baby. Exactly, the amicus cream, it can cover up whatever. So they really felt what Elaine was saying because they were using the amicus cream. Another argument could be that with all the surgeries and things going on these days, people can look substantially younger, but are people that were born in 1945 getting plastic surgery like that in Virginia? I don't know. Maybe a better argument for like if they brought the case in LA. I'm not sure. But yeah, no one questioned it until right now in this motion. Okay, we have Cal saying Elaine looked like she's such a scatterbrain that I wouldn't be surprised that she was the one who got those dates wrong. Well, I'm scattered brain just reading this motion. It's back and forth. It's confusing for me. Okay, so I wouldn't be surprised if she was the one that got the dates wrong as well. Okay, Monique and Co says Elaine had a chance to get jurors, so I don't get how they can argue that there was an issue after the fact. Or to vet the jurors. So you don't understand how it's an issue after the fact. And that's the issue, because someone was there that you thought was from 1945, and like McGuffer said, you didn't realize they was 25 years younger. Must be the Amica cream. Elaine must have really believed in her Amica cream, right? And they didn't question it while they were on the juror. But I think they're just trying to pick any and everything that they can throw at the judge, because remember, during the interviews, it was that the jurors were looking at media. Now it's that this juror was supposed to be from 1945. And even if they were from 1945, would it really make that much of a difference? That I feel like that should be a question as well. If you had an older person there, would they have been more favorable to Amber? Or would someone from 1945 also not believe her? Someone from 1945 might have a little bit more animosity towards her because they can see through the BS, right? Who knows? We have Hella Swanky. Welcome back to the live stream. Nice to see you, or to see your username, because I can't see you. Dasby says surgery. They don't need that. All they need is skin plus. I love to see it. Like, you guys really do come to my streams, watch my streams, and everything that we cover. So yeah, we got the Kim Kardashian Skin Plus. Amica cream is going out of business. Oh no. What do you call it? Kim Kardashian is just Skin by Kim, and she's Skin, and then Skin Plus is our fellow Black woman-owned business. She's not making her own product, so they might need to go get a facial. She's up in New York, so maybe they could get over there to get their facial done, look younger, or Amica cream. They got a lot of options to take off 25 years of their life. Okay, Ryan says, people tell me I look like I'm in my 40s, about to turn 59. That's a good thing. So maybe the same thing happened there. So that's about, what, 20 years? 20-year difference. So yeah, some people can pass for that, but it still took them a really long time to realize that. I feel like they're picking at this point. All right. And we have Kath saying, one could argue that Asians look younger. That is true. I wonder who Juror 15 was, because I don't know exactly off the top of my head what their demographic was. If she was referring to the Asian juror in a mostly Asian jury, if Rob and the other got that part right. Yeah. So that would be the question of who it might be, because there are certain races that do appear younger than they are. And there are certain races that appear older than they are. And there's just certain people that age faster than other people, and certain people that age slower than other people, no matter what your race might be. Just genetics, right? All right. Kat says, please don't think I'm racist. I'm Asian. It's okay. We know some people just age a little better. It doesn't matter the race, right? Some people age a little better. All right. So we kind of already went through some of the arguments, but I'm going to pop into a little bit of the arguments of like the points that she's making. So let's start over from the beginning. She's basically saying the damages awarded by the jury are unsupported by the evidence. Remember, Johnny Depp was awarded $10 million in compensatory damages, which was like actual damages, and $5 million in punitive damages, but the $5 million was reduced to $350,000 as limited by the Virginia statute. Okay. And she's basically saying the damage awards are unsupported by the evidence presented at trial and cannot be upheld as a matter of law. It goes on to list some of the rules, saying where damages awarded are too small or too excessive, courts have the authority to order a new trial on all issues or solely on the issues of damages or remitter. remitter. Can I say that word? While as a general rule, trial courts should not disturb, as a general rule, let's repeat that. Trial courts should not disturb a jury award that has been fairly rendered based upon competent evidence. So Amber is saying that the evidence is not competent. And Johnny's going to say that the evidence was competent. Okay. Moving on, saying circumstances which compel setting aside a jury verdict include a damage award that is so excessive that it shocks the conscience of the court. Like we said earlier, I don't understand how it could be so excessive to shock the conscience of the court when he requested $50 million from the beginning and he's a superstar movie star. And Amber Heard requested $100 million, and she's not a superstar movie star, but she's been in some movies, in my opinion. She's not a superstar, but she's been in some movies, and she's requesting $100 million. So why is Johnny Depp getting $10 million a shock to the conscience? It doesn't shock me. He's already a millionaire. Okay. Creating the impression that the jury was influenced by passion, corruption. She's probably going to harp on the passion because people love Johnny Depp, right? Or prejudice that the jury was misconceived or misunderstood the facts of or the law. The award is so out of proportion to the injuries suffered as suggested that it is not a product of fair and impartial decision. And maybe they weren't fair and impartial because they didn't believe Amber Heard. I'm sorry, I'm getting feisty, but it's just bringing back bad memories of watching her on the stand. Like, ugh. Not a good person to cover her case, right? Okay, we have Jennifer says, I have super dry skin, so I'm wrinkled AF for a 37-year-old. It's okay. We got the Skin Plus. We got Kim Kardashian skin, and we also got Amica cream. It is okay. All right, we have Tiny D saying, I'm good. Oh, you guys are chatting in the chat as always. McGuffer says, you're good. I was trying to do math to see what it would be. Sorry, lost the chat. See what it would confuse a 77-year-old with a 52-year-old, which I guess is basically Dolly Parton, right? Possible. Yeah. Okay. So yeah, that would be the math from 1945. Yeah, that would make you 75, right? Yeah. Yeah, I don't know. I think it's a little bit harder to confuse someone that is near 80 and someone that is near 50 versus someone that is 40 and someone that's like 30. Like someone's 50 and 30, I feel like that can be more confused than someone that is 80 to 40, if that makes sense. I think that makes sense. Okay. Ryan says like 100 mil. Yeah, she asked for $100 million on her counterclaims. So $10 million, I don't think that's outrageous. Hello Swanky says to Jennifer, OMG, same. It's so hot in LA. I'm not great. Oh, and got the bright idea to bake. I'm blaming bacon too, or whatever it's called, and all the cake decorators I follow. Don't bake outside. Okay, we got Tanya says, bring me some poutine and it's a deal. Oh, I don't know what you guys are talking about. I don't know what you guys are talking about. Okay. Let me see if I can figure out where I'm at. Okay. McGuffey says, maybe they shouldn't have put the jury to sleep with all of the depositions. Right. That's a whole nother story that we can get into, right? Monique and Co says, could Johnny argue insufficient evidence for Adam Waldman's statements and agency argument? Amber didn't get much info because of the attorney-client privilege. Yeah, he can argue. The thing is that everything that Amber is bringing, Johnny can probably bring other things that are probably better arguments than what Amber actually has. Like I said, I feel like Amber is actually just nitpicking at this point. Some of the stuff have a little backing to what she's saying, but at the same time, I don't think that they're strong arguments. I honestly don't think that they should have found Johnny Depp liable for anything that Adam said. And on top of that, even if they did find him that he was an agent, I don't think that they could find malice in the statement that he made about the hoax, because that's the way he believed that it happened. He did not know that it was false, that it happened that way. So I feel like there are several ways in which Adam's statements failed to tell you the truth. Okay, we have Ryan saying Ramesh Bawani was found guilty. I'm not familiar with that off the top of my head. Tanya says Boss Attorney Bri might end up arguing the case if she gets too upset. maybe a little bit. I just, we went through a lot watching this trial, and for her to come back and just try to re-argue her case in this motion is it's too much. Go ahead and get feisty, Bri. Jennifer says feisty Bri is fun, Bri. Okay, you guys like the feist. We like the feist. All right. McGovern says I'm good with the outcome, but I would have loved to watch this trial with Amber's original attorney, Roberta Kaplan. Yeah. I would love to see how some of this stuff would have turned out if other people were arguing it. I think a couple of law tubers did mention it seemed like Rottenborn and Elaine had two different strategies on the case. And now that, and I didn't realize they were from two different firms at first. And now I realize maybe why that might have been. They might not have collaborated to the extent that they probably should have, working in two different offices. So that would be interesting to see pretty much anyone else argue the case, or maybe even just one firm argue the case on her behalf. Okay, so let's see what we are getting distracted in the comments again. You know how I get. Okay. We have here the jury determination of 10 million in compensatory damages is excessive as a matter of law, as there is no evidence to support the verdict. In your opinion? Okay, Mr. Depp was limited to damages from December 2018 to November 2020. And so this is like the crux of her argument. She's basically saying that some of the damages that was awarded to him came from before 2018 and then also after 2020. Hard argument to make because you don't know what the jury based their information off of. You have no clue because we have the verdict sheet. Should I find the verdict sheet? Let me see if I can find the verdict sheet. I know we have it. It literally just says $10 million on there. So let's see. Jury verdict. Was this from this case? Nope. That one is from Kylie Jenner. Let's see if we can find the one from Johnny Depp. Nope, that one's from trademark infringement. I got too many. Jury verdict. Or maybe I'm confusing it with something else. Did we get the actual verdict form for that one? I think we did. Okay, I can't find it for now, but if I find it later on, then we'll look at it. Okay, so they don't really know what the jury actually based it on. So I don't think this is a good argument. And then she goes on to talk about how UK found that he had committed 12 acts of domestic violence. So obviously, according to her, he is an abuser, right? Okay, and then I'm going to hop down. Like I said, this long document, so we're skipping around here. We go on to see her talking about, notwithstanding Mr. Depp representation, he would not attempt to claim any damages other than during the 2018 and 2020. Mr. Depp made no attempt to limit his damages, and his counsel in closing made that clear, stating that basically they again brought up the DVTRO, which is what she based her statements on. And so they're saying the fact that he brought up that TRO, the DVTRO, alone justifies setting aside the verdict and ordering a new trial. She then goes on to say that Mr. Depp presented no evidence of any pecuniary damages in the limit between 2018 and 2022. Again, you don't know what the jury based it on. Maybe they felt that his reputation was damaged by $10,000. And you can kind of infer that. You don't need actual evidence, like specific evidence. of it, like saying, oh, I went to the doctors and the bill was $100,000. You don't need that for reputational harm. You don't need that for emotional harm and things like that. So again, you can't say that, or she can't say that. And then she goes on to talk about the reputational damages. And then again, she's probably ignoring like his emotional well-being, him feeling sad. Maybe he didn't start feeling sad until between 2018 and 2019, right? So go on to say, moreover, Mr. Depp cannot demonstrate any reputational damages from the op-ed because the evidence, including Mr. Depp's own testimony, was that Mr. Depp lost nothing less than everything as of May 2016. When Mr. Heard, this is a typo, Mr. Heard. Amber Heard is now Mr. Heard. Distractions, right? Obtained the DVTRO against him, and that then there were 2 years of just constant worldwide talk about Mr. Depp being this wife beater before the op-ed, and even published, including the Sun wife beater article. But you can't, maybe I'm just against Amber Heard, because I'm like, you can't use that against him when she went all the way back to 2011 to prove that he was the beater. So was he not supposed to include evidence to contradict what she said? That sounds like a double standard to me. All right. Moving on. In addition to any reputational damage that the op-ed, which never mentioned Mr. Depp's name, again, arguing that it wasn't about him when we know it was about him is not productive to your argument, would have been where was I at? All right. In addition to any reputational damages after the op-ed never being named, would have been non-existent, at best nominal, compared to the Sun article and the lawsuit brought by Mr. Depp, the publicity over Mr. Depp's lawsuit against the Sun in United Kingdom, and the subsequent trial judgment rendered against Depp. Basically saying that he was more damaged by the outcome of the UK trial, and he shouldn't be claiming damages for that because he is the one that actually brought the UK trial to sue, right? Next reason why they're saying that he is not entitled to a jury verdict is that there's no pecuniary damage from the op-ed. Taking the evidence in light most favorable to Depp, there is no evidence upon which a jury could have reasonably relied to determine that Mr. Depp suffered any pecuniary damages because of the op-ed. Again, they go on to talk about how there was talk that Johnny Depp would not be in the Pirates 6 in as early as October 25th, 2018, and the op-ed was not published until December 18th, 2018. So basically saying that he lost that movie, or he wasn't going to be in that movie before the op-ed was even published. It then goes on to talk about how they had not even shot the movie till this day. So how could he have lost the contract, and that Disney would not pay him $300 million or a million alpacas or whatever it is that he said. So that's one of the reasons why they're saying he could not have reasonably been awarded this money. However, that is not the only evidence that he presented to show that he lost money. And on top of that, he could have been awarded $10 million for his emotional distress, for his embarrassment, for whatever else the jury, and a lot of LawTube actually said it looks like the jury did not believe his evidence regarding how much money he lost on the movies because they did not award him the $50 million. Remember, he presented evidence of like $40 million of revenue loss, and the jury only awarded him $10 million. That sounds like they based the $10 million off of more of his reputational harm, his emotional harm, his humiliation, all of those things, which you cannot timestamp to 2016 in the way that they're trying to do it. So I hope that makes sense. I hope I'm not just ranting at this point. I really hope I am not just ranting at this point. All right. Okay, so we have the jury, okay, popping back over. Okay, the Jury's compensatory and punitive damage award was excessive. Let me see how long this section is because I did skim it earlier. It's short. Okay, I did want to read this one. Okay. Given the jury did not and could not award Mr. Depp damages for any financial or pecuniary loss based on the evidence presented at trial, again, she's very much so limiting what they could base the damages on. The only damages the jury could possibly have awarded Mr. Depp were reputational damages. And it cites a citation that says, at no point in his testimony or through his expert did Mr. Depp ever claim damages for emotional distress. They can infer those things. I think I have the jury instructions. Let me not say it and I really don't have it, like what just happened. Well, let's not go into that because we got a lot more of this document to go through, honestly. Okay, let's not get distracted. Okay. Even though reputational damages are not pecuniary, a jury still must award damages that resulted only from the defendant's wrong and not from other causes. Moreover, reputational damages cannot be used to punish a defendant. Yeah, that's what the punitive damages are for. I could not think of the word. That's what the punitive damages were for, and they gave him $5 million for that. So that's not what they awarded it for. I'm sorry for you. Okay. We have more. Where are we at? Okay. Moreover, reputational damages cannot be used to punish the defendant for all the negative publicity that plaintiff had received, separate from alleged defamation. But this is precisely what happened here, and it was compounded by the exclusion of the evidence in the UK judgment. So this is a lot going on here. So what are you guys thinking here? I see some chats coming in at a little rapid speed here. So let me check out what you guys are saying. We have Kath saying that get McGruffer's point. It took some time, but I researched the judge that looked like she was at least 10 years younger than she looked. Judge Janine Pirro. She's 71. She did not look 71. Okay, we're still talking about the age thing. Jennifer says, I tell my kids that you don't get to decide how another person feels. You have to listen to them and accept their feelings. That is absolutely true. Absolutely true. All right, we have McGuffer saying to Jennifer, all thanks. I love chatting with y'all, especially needed by the time I get to Thursday. Yes. The chat is where it's at. The chat is where it's at. Okay, we got Jennifer saying, I could see Disney paying him a fair amount for Pirate 6. I wouldn't be surprised if they give him some alpacas. They said they're not paying him $300 million or $1 million alpacas, okay? So as long as he's not asking for $1 million alpacas and he's not asking for $300 million, they might cast him in the movie. I'm gonna mess this up. Anton, the gentleman, says, wait, alpacas? Yeah, he said that in his testimony, and they brought alpacas to the court. So it was like a thing. Okay, McGuffer says, I think Juror 15 might be the guy on the end who was rolling his eyes at Amber Heard the whole time if it goes up in number order. That is possibly why they are upset, and maybe someone born in 1945 wouldn't be rolling their eyes. I don't know. I don't know where they even got the idea to investigate that one, right? Okay. And we have Anton Gentleman saying, I came from TLA channel some time ago. Glad to see some traction for Bri. Well, thank you. And welcome back to the channel and the live stream. Definitely appreciate you popping over. I was on TLA the other day talking about the Nipsey Hussle thing. So if you guys haven't checked out the lead attorney, make sure you go over and check him out as well. McGovern says, all of us are trying to get into the mind of Elaine, and I feel like it's just two hamsters trying to run on the same wheel. Yeah, I don't know if she's the main one that wrote this document, but she is the first lawyer listed on this document. So I'm thinking she had a pretty big hand in coming up with this document. And as we see, she was one of the main attorneys on the floor during the trial. Okay. I don't know if we're going to make it through this whole thing today, guys, but this is all of this is more of like a long summary of what I read earlier in the introduction. So if we hop around a little bit more, that's okay. We covered the crux of it. We're probably going to get more into the comments coming up here soon. I do want to get into some of her arguments about the jury, so I'm trying to get through this thing here. Okay. Mr. Depp is not entitled to damages for any conduct prior to the op-ed. Again, she's going with, there is no evidence of damage to Mr. Depp's reputation caused by Ms. Heard's op-ed. Instead, Mr. Depp testified that the damage to his reputation was when Ms. Heard obtained the DVTRO on May 27, 2016. I don't know if I got that from his testimony. They then go on to cite some of his testimony, which I do not want to go through. So we're going to skip. And as you can see, there are several articles talking about Johnny. They are not showing us what year they were published in. So I'm not too sure if it's going to, if we can say that that was more during 2016. Okay. After a 6-week trial, Mr. Depp went back up and on the stand and reiterated this testimony to the jury, stating that Ms. Heard's action on May 27, 2016 changed everything because it gave her the ability to claim that she was a DV survivor. Okay. He again did not state that it was the op-ed that damaged him, but the accusations from May 2016, claiming that I have spoken up for what I've been carrying on my back reluctantly for 6 years. And the thing is that the 2016 could have been the start of it, but the 2018 is what put the nail in the coffin. And so he may be just trying to remind them of what she did in order to get that restraining order, in order to look bad. So I don't like that they're harping on that fact that they talked about the 2016 the DVRO, because that was a substantial factor in her being able to say that she's a DV survivor. Next thing he's saying is Mr. Depp is not entitled to damages for alternative causes, including the Sun publication and ensuing litigation brought by Mr. Depp, the UK trial and surrounding publicity, and the UK judgment. The evidence demonstrates that any damages caused to Mr. Depp after the op-ed were not because of the op-ed. There were a number of alternative casualties. The most significant was surrounding the Sun's April 2018 publication in the UK for the article by Dan Wooten. And then they basically go on to say that he cannot really distinguish the damage that that was caused to him by the UK article and what Amber Heard said in her own article. That's the main argument there. Then she goes on to say Virginia case law supports setting aside the judgment. And then so this is where we're going to get into the things that she compared Johnny Depp's case to that is just completely ridiculous. So as we know, Johnny Depp is a mega superstar, right? He's been in a million movies. He's been acting since 1990s. What is that? Well, it's over 30 years. So he's the mega superstar. People know who he is, right? Okay. Amber Heard is going to cite some cases for us and let me know in the comment section whether you think this is similar to Johnny Depp's situation. So her argument is that Virginia supports setting aside excessive award damages. Okay, let's check it out. All right, so excessive award damages that Virginia supports. A teacher complaints about a plaintiff teacher's performance. The court affirmed the judgment that the teacher was defamed. It held that an award of $1 million clearly would have been excessive, and that the evidence does not demonstrate that the trial court abused its discretion in reducing the award to $100,000. Now, do you guys think that Johnny Depp is more similar to a teacher being defamed about their performance? Do you think that that $1 million that was awarded to a teacher is the same equivalent to maybe Johnny Depp only being awarded $1 million? Let me know what you guys think there. Okay. And then the next one is for in the Gazette versus Harrison, the jury awarded compensatory damages of $100,000 for publication of an advertisement accusing plaintiff of racism in the campus newspapers of the university where plaintiff was a professor, accusing the plaintiff, who is a professor, of racism. Again, the Virginia Supreme Court held that $100,000 in damages bore no relationship to the loss sustained by plaintiff. The verdict of $100,000 is so out of proportion to the damage sustained to the excessive as a matter of law. Again, we're comparing Johnny Depp to a teacher and to a professor. Do you guys think that's the same thing? I think that Johnny Depp makes a little bit more money, and I think the fact that they were asking for $50 million also supports that $10 million is not excessive in this situation. So let's see. We have Jennifer Miller saying, I am having a great day. Ain't no live like a Bri Hive live because a Bri Hive live so fly. Yeah, I haven't said that in a long time. So thanks for bringing the chat back, Jennifer. I always think about saying it before the live stream, and then I just never get to it. All right, we have Deacon Fatal saying, hey, welcome back to the live stream, saying, I'm not messing with any highs because that will always be a mistake. You got to join the Bri Hive, though. Okay, we have Jennifer Miller saying, sting the like, subscribe, and join buttons to pollinate Bri's channel. Thank you for joining us tonight. Come back on Tuesday for more great law coverage. Exactly. Thank you so much, Jennifer. Always hyping up the channel. If you guys have not hit the thumbs up button, go ahead and hit the thumbs up button. It helps the channel out tremendously. Also, subscribe. We have been working on 8,000 for a while now, and join the channel because the members get these cool little things next to their name, and they get cool little emojis that are not available in the regular emoji section. Okay. We have S. Lee saying, this document is horrible. I hope Judge A sits on it and makes them really appeal and pay the bond. Yes, I can agree with you on that. And that's why we're skipping through a lot of it. It's long and it's confusing. Okay, we have Kath saying the Washington Post article was when I paid more attention to the DV accusations against Johnny. Before that, I never even realized that Amber was Johnny's wife and that she accused him of DV. That makes sense. That makes sense. I had no idea who Amber Heard was. And I'm not a Johnny Depp fan, so maybe that's why. But yeah, I had no idea who she was. And I've said this on several lives. I had just watched Aquaman, and I was like, she was in that movie? And everyone was like, she was the main girl. I was like, had no idea. She just didn't look the same to me. Maybe it was the red hair. I don't know. Okay. Deacon Fatal says, okay, some of this is very subjective. Neither is a great actor. I'm too poor even weigh in on this one. As Lee said, haha, he is not the same as a teacher. His salary is millions per movie. Exactly. 20 million minimums. Okay. We're not talking about 60,000 if they're even paying teachers that at this point, right? We're not talking about that as far as a teacher's reputation being harmed. And remember, we are talking about a public figure. You have to prove actual malice. So someone intentionally trying to harm that person's reputation is going to cost a lot more than a teacher whose standard is that you negligently spread something that was false. Completely different standards. We are not talking about the same thing here. Okay. Pixie Dust says the judge has already signed verdict into record. The motion means nothing. Only appeal is open now, and she got that to pay the bond first. Yes, exactly. This is not an appeal, guys. These are post-trial motions. Basically, just putting their issues on the record. Remember, this has to do with all the objections that they were given throughout the trial, even though they didn't object to Mr. 19 or to Juror 1945/1970. But they're putting it on the record to get ready for their appeal, right? They're hoping that they'll grant the motion to send it back, but most likely they're going to have to appeal in order to get anything changed because Judge A probably does not want to deal with this again. Okay, Deacon Fatal says no, it's not. Deacon Fatal says no, he isn't a teacher. Yeah, Johnny Depp is not a teacher. He's an actor. Deacon Fatal says, I am in the Bri hive, though. Yes, you got to be in the Bri hive. Don't mess with like beehives, but Bri hive, that's okay. It's okay. All right, we have Kath saying, unfortunately, teachers earn way less than they deserve, but looking at their paychecks, you can't compare Johnny's paycheck to the teachers. That's what I'm thinking as well. And on top of that, we are talking about different standards, different reputational harm. If someone was negligent in spreading something false about you, would it be harmful to your reputation? Probably yes. But if someone is doing actual malice, they're actually putting it out there. They're okay at the school. They published it to let's say it's a university of like 10,000 people. They published it to 10,000 people. Half the students don't even know they have a school paper. The other half of those half don't even go into the library to pick up the school paper. The other half of that half, they read the newspaper. So maybe you're getting to about 2,000 people, if I did that math right. But Johnny Depp's, that is broadcasted to the world. That is not the same type of reputational harm as a teacher. I'm sorry. Like, teachers are great. They provide a lot for us, but they're not losing as much money as Johnny Depp would lose if his reputation is harmed, right? Depending on what kind of teacher they are, right? And Jennifer with the emojis, but I can't see them because StreamYard doesn't like them. We have Deacon Fatal saying, no, they are not. Nope, not the same. And we have Katoma coming in with the emojis. Thank you so much for the support. And we have Tanya D saying, I want a gavel emoji so I can use it and say I object. I think I can now add more emojis. So I thought I did a gavel emoji, but I guess I didn't. I think I just did it on the badges. So I think I can add another emoji if I'm not mistaken. I have to look into the studio. And you guys are dropping the emojis, but StreamYard does not like it. They just don't show them. I don't know why. Okay, we have Deacon saying, if I showed this to a teacher, they would scream. No, you cannot. Yeah, and so they should be paid more, but should they be paid Johnny Depp's salary? I don't know. But like I said, it's definitely not getting displayed to as many people as it's going to get displayed to for Johnny Depp. A lot more people are going to see. We saw how many people were watching on live stream. We had like Legal Bites had what? 50, 60,000 people at a time. Emily D. Baker had 100,000 people at a time. Ricada Law had 60-something thousand people, 60, 70,000 people at a time. Law and Crime and Law, whatever that channel is called, had hundreds of thousands of people at a time. So you see how much something about Johnny Depp will spread versus us normal people. It's not going to spread as much as a 30-year celebrity. I'm sorry. Tiny D says, question, did Depp's team file any motions? Not that I've seen. This one was just filed on July 1st. So I don't think that they've done any responses or that they've done their own motions. It could be because I lazily researched that I didn't see it. But from my knowledge, no, they haven't filed anything. Okay, Kotoma says, teachers in my area make about $30,000 a year, maybe a little more. Yeah, and so definitely would not be the same as Johnny Depp's damages, right? So that 100,000 is probably more realistic for that teacher, depending on what type of teacher she was. Was she or he or she? I don't know if they gave the gender, but it would. $100,000 is probably more appropriate for reputational harm than $1 million. But for Johnny Depp, who makes $20 million just to sign up for a movie, $10 million is probably a little less than he should have been awarded, right? Okay. Kath says, question, why file this if it's most likely going to be rejected? Why not focus on the appeal instead? She probably doesn't have the resources or hasn't really had time to put the appeal all the way together. I would also... I'm trying to think if filing this would delay the need for the appeal as well. I don't know Virginia law like that, but it could potentially push back the time for them to file the appeal, which they're probably going to bring these same arguments. So it may not even be wasting time, to tell you the truth. But to see if you can get it done before taking it up to appeal is a smart strategy. Okay. We have Anton the gentleman saying, or even then matter in which they get paid. Teachers get paid regularly and the reputation does not hold as much weight. Exactly. Teachers are great, but like you said, it's not being spread to as many people. And how many teachers have you had that you have talked mess about because you didn't like them and they still had a job, right? There have been teachers that have done horrible things and they still have jobs. So yeah, I don't think it carries as much weight. Sage Moon, I haven't seen a comment from you in a while saying it's definitely not the same thing. They're reaching. It's like when that expert witness compared Amber Heard to Gal Gadot, Zendaya, and Chris Pratt. You mean they're not on the same level? It's completely different. Shout out to the teachers though. Yeah, exactly. 100,000 is a lot more reasonable for a teacher. 10 million and probably more is more reasonable for Johnny Depp. Sorry. So it doesn't, the point is that it doesn't shock the conscience. Deacon Fatal again, where he isn't a teacher. Now, do they both bring money? Yeah, but what's the real cost? Exactly. So I think everyone's right on the same wavelength of that. It's reasonable for a teacher to be awarded 100,000, even though they said it wasn't reasonable for the professor to be awarded 100,000 because basically it didn't affect his career, is what they said. Basically, it was a nominal win. But for Johnny Depp, I don't think 10 million is so much to shock the conscience, especially because Amber Heard's counterclaim that she brought was for $100 million. And if $10 million would shock the conscience for Johnny Depp, then definitely $2 million for Amber Heard will shock the conscience as well. So I don't know if she wants to play with that fire. Okay. I am keep going in the chats because I get distracted in the chats. Okay. As Lee says, they only have 30 days from 6/24 to appeal. So we will see what other desperate measures they try. Yeah. So, yeah, because, yep. Okay. Yeah. So they do have the 30 days. So this is probably just what do you call it? Like a rough draft into the appeal if she can put the bond up. All right. And they're saying it doesn't stop the appeal clock. Yeah, so sometimes it could be that it will push it back, but like I said, I'm not that well versed in, well, I'm not versed in Virginia law at all. Everything I get is from the laws that are presented to me. So, like I said, it's probably just a rough draft, getting it out there, getting the publicity on it. Not that it matters for what the judge will decide, but Amber Heard at this point, right? We have Deacon Fatal saying she is being petty. I think they are both being petty. And again, I don't have the time to worry about rich folks' problems. They both still royalties, right? Right. And so that's what I say. I feel like Johnny Depp got his point out. So even if Amber did appeal, if I was Johnny Depp and I didn't want to spend all my money on this nonsense, I would just be like, okay, whatever. I don't really need your $10 million. I probably spent more than $10 million defending this. So whatever, I got my story out. You're a liar. And you look bad on the stand. I feel like that's worth more than $10 million. Her looking like that on the stand. Okay. So, okay, we went through that one. She then cites some other cases, but they were not binding. So I'm not going to cover those ones. So let's check out. She then goes on to say the verdicts on the complaint and counterclaim are inconsistent and therefore should be set aside. The Virginia Supreme Court has held that jury verdicts that are irreconcilably inconsistent cannot stand. In that case, the Supreme Court instructed a new trial is necessary when portions of the jury verdict are irreconcilable. All right. Here, the jury's verdict in favor of Mr. Depp as to his defamation claim and in favor of Miss Heard. She's not Mr. Heard anymore. Miss Heard. Okay. As to her claim of defamation are inherently and irreconcilably inconsistent and therefore cannot stand. The verdicts found that Mr. Depp did not abuse Miss Heard at any time, while at the same time necessarily found that Miss Heard did not lie about being a victim of domestic abuse. That is a misstatement of the facts. And in particular, abuse that occurred May 2016. These findings are entirely inconsistent. Okay, I hope that wasn't too bad of a reading, but it was just too many words. Okay, so that is a misstatement of the facts, because the thing that Amber Heard won on is that she did not complete the hoax in the manner that they are describing. I wish I remember what I saved the jury form under. Darn it. Johnny Depp trial. Let me see. We got all the files on the computer. So let me see if I can find this here. YouTube. Oops. Nope. Not the right one. Please have the verdict. Oh, I guess that was the right form. I just clicked out of it. It didn't look right. So I thought it wasn't right. Okay, let's see. Which one did Amber Heard win on? That's for Johnny Depp. This one is for Amber Heard. She won on... Okay. She won on number 2, right? Yeah. So she won on number 2. So in my opinion, she won on a technicality. So this is the point that she won on. And this is why I'm saying it's a misstatement of the facts. She won on, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to the face or property. So Amber and her friends spilled a little more wine and roughed up the place, got their story straight under the direction of a lawyer and publicist, and then placed a second 911 call. Now, that is not what she just said here. She said that the verdicts found that Mr. Depp did not abuse Heard at any time, but at the same time found that Miss Heard did not lie about being a victim of domestic abuse. They found that she did not conduct the hoax in the way that Mr. Waldman explained it. And in addition to that, they found that she did not win on the first one, that again talked about a hoax. Or no, it talked about sexual violence. Okay, yeah, so she lost on that one. But either way, they did not find that she did not lie about being a victim of domestic abuse. They found that she did not, or that Waldman was telling a false statement about the way that the hoax occurred. So again, misstatement of the facts, which we know that Amber Heard's team likes to do. In overruling Ms. Heard's demur, the court held that the statements Amber Heard, "I spoke up against sexual violence and faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure, represented domestic violence and felt the full force. And then I had the rare vantage point," and those are just the statements. Their opinion. In reaching that conclusion, the court held that the inference could be made based on the events surrounding the parties' divorce, including the allegations from May 16. This holding means that the jury, to have found Mr. Depp's favor as to the defamation claims, it is necessary they had to find that Mr. Depp did not abuse Miss Heard at any time, including May 2016. Sorry, guys, I'm thinking. To have found in Depp's favor as to his defamation claim, it's necessary they had to find that Depp did not abuse it. Yes, okay, that's true. Okay, I understand that one. Okay. Conversely, this court overruled Depp's demur on Ms. Heard's counterclaim. It held that the statement made on April 27th that implies Ms. Heard lied to perjure herself when she appeared before the court in 2016 and obtained the temporary restraining order. Moreover, implies that she lied about being a victim of abuse. And like I just explained, no, they're saying that the way that the hoax occurred was not truthful. That's what that is. Okay. let's go. The next thing that she is saying, so now we're off of the that is inconsistent based on those things. She now argues that the First Amendment bars recovery for defamation by implication when the statements at issue are true on their face and involve a public figure or matters that concern public concern. The Supreme Court of Virginia has never decided whether facially true statements can support a claim of defamation by implication when they involve a public figure or matters of public concern. However, the court signaled that this doctrine does not apply in these circumstances. There, the court distinguished this case where the Fourth Circuit held that the speech issue did not impart a defamatory implication for the facts in Pendleton. Okay, they are just giving case law here, so we're going to skip through that. All right. Similarly, courts that permit public figures to recover for defamation by implication generally define this tort as occurrence. So they're basically trying to establish new case law and finding that the statement was true on its face, and therefore he cannot win on defamation by implication. All right, let's check out the chat. I think we're more than halfway through, but still got a lot to go. But like I said, we're going to be skipping around a little bit more. Okay. So I missed a lot of chats. Where are we going? All right. We have Anton, the gentleman, saying, Amber lies on the stand where flagrantly foul. Yeah, I feel like they're going to feel that she's lying through her writing as well. I feel like it. Kath says to Lee, if it doesn't stop the clock, feels like she's wasting too much time. If she wants an appeal, or if she wants to appeal, then what are they going to do? Use the exact same document for the appeal? Can you do that? They can do that and just add a little bit extra. It might be like a waste of time if Judge A rejects it and then they appeal it and then they also reject it. Could be the same thing. Jennifer says a gross misstatement of facts. I agree. That's why I took so much time to explain it. Probably confused myself in the explanation, but yeah, misstatement of facts for sure. Esley says, this part made me roll my eyes. They are not the same. Elaine is being foul at this point. And is that something new for this case? They are always with the misstatement of facts. They are always coming with that. I don't understand their purpose there. All right. Deacon Fatal says, yes, I think so. Well, then stop right there. But they won't. No, they will not stop right there. Tanya D says, I would have awarded her $1, certainly not $2 million. And so my theory is, if you guys remember, when they came back with the jury verdict, they had to send them back because they left an award line blank. And I'm assuming that it was for Amber Heard, and they probably wanted to award her $0, just like they awarded her zero punitive damages. But someone should have told them that they could award $1. If someone said that, I think they would have put $1 on there. But maybe they were trying not to be unfair, because they came back too fast with that. They came back too fast. So you can tell. In my opinion, it seems like they just kind of put numbers on the paper to tell you the truth. They didn't really assess the values that they were given as far as actual solid numbers that they were given, in my opinion, because they came back too fast with that. I'm saying with the $2 million. I don't know if that's what it really was, but I'm going to assume it was the $20 million. I mean, not the $20 million, the $2 million. Okay, Kath says, but hey, if she wants to spend so much time and money for this, that's not my money. I don't think the court should stop spending too much time on Amber's case, but I guess that's how the U.S. courts work. And when they pay and they put the money in and they appeal, it's just what they have to do. So they can't just, they can technically, no one would know if they didn't read it and they just reject it. But, you have to, professional responsibility and be, I can't think of the words right now, but you can't not read it and waste your time on it. So, but who knows if they don't read it, They don't read it. We would never know. Okay. Deacon Fatal says, real talk, this is very dangerous for a lot of people. As someone that had to respond to several DVs, this is dangerous AF. Yeah, and that's just the DV claims, especially under family law, which is what she got her DV claim under. They hand them out like candy at a free sample store. So I agree with you there. McGuffrey says, Bri just set my Alexa off. It tried to play From Now On by Hugh Jackson, whatever that is. What did I say Alexa? That's crazy. Okay, Deacon Fatal says, I get she has a personality disorder. Clearly has a personality disorder, right? They both have it. And from an LE perspective, I would stop right here. But she might not, because that's part of the disorder. Yeah, she's going to keep going. She's going to keep going. In my opinion, she doesn't have anything else to do. So why would she stop? She would rather spend her money on this than to pay Johnny Depp. It's not my thing. Jennifer Miller says, I don't have one because of that. The Alexa creepiness. I just got an Alexa. I think she's Alexa. Alexa is by Amazon, right? She might start talking now too. Deacon Fatal says, it will never be her fault. Yep, never be her fault. Jennifer says, Elaine acts like she was the abused party. She has identified so much with Amber Heard. Like, I don't think she really separates herself from her at this point. The way that she argued, the way how passionately she got about things, I feel like she has morphed herself into Amber Heard's mom or figure or something of that nature. Not like she's represented an abused person. She might believe her. She was probably dragged in so far, she has to believe her at this point. Cameron says $1 would still be too much in my opinion. Well, it's called a nominal award. You can't do like 1 cent. I mean, I guess you could. I wish they did $1 so that Johnny Depp could have just gave her $1 right there in court. That would have been hilarious. Okay, back to the document. We have a little section saying the jury's finding of defamation by implication with respect to the op-ed. With respect to the op-ed headline statement is contrary to the law and unsupported by facts. The jury verdict with respect to the headline should be set aside because under applicable laws and facts, Ms. Heard initially made or published or nor republished the tweet. There's no support for the conclusion that Ms. Heard initially made or published the headline. The newspaper added the headline, and Ms. Heard played no role in authoring or publication of the headline statement. But you didn't approve it before they put it out? That seems a little strange. To establish defamation by implication, Depp must prove the elements for each statement at issue. Okay. There is no evidence that Ms. Heard ever made the headline statement as required. They implied it from what you said. Sorry. For defamation by implication. And didn't they already rule on this? So, okay, she's just bringing it back up as a matter of law. Okay, the newspaper added the headline, plaintiff must prove that defendants made the statement alleged in the complaint. Similarly, no jury could conclude that Ms. Heard published the headline to prove publication. It is generally sufficient to show that when the defendant addressed the defamatory words to the plaintiff, another person was present, heard the words spoken, and understood the statement as referring to plaintiff. Here, Ms. Heard never addressed the headline to the plaintiff. Really? She never wrote or conveyed the headline message to the plaintiff and therefore did not publish it in the first instance. Noting that sufficient showing required defendant address, you don't have to publish it to the plaintiff. You have to publish it to a third party. What are they talking about? Publish it to the plaintiff. You have to publish it to a third party. She never wrote or conveyed the headline to plaintiff. Yeah, no, that's all the way off. I'm sorry, I took a long pause on that. But yeah, you don't have to say it to the plaintiff. You have to say it to a third party. Someone can't come up to me and say, you know what, Brianna, you get on YouTube and you just lie. You just lie. That wouldn't be defamation because they're talking to me. They're just talking smack to me. But if you go behind my back and say, hey, uncivil law, you know, Boss Attorney Bri, that girl, she lied. You know, she lied about, I don't know, make something up. She lied. Let's say, she lied about being engaged. She's a liar. She's not really engaged. And you go tell Kurt from uncivil law, then that would be defamation. You're publishing it to a third party. But if you're just telling it to me, that's not defamation. That's not going to ruin my reputation because you're saying it directly to me. So I don't know if that was a typo or what, but that's not correct. Third party, not to the plaintiff. Sorry about that. That was a tangent. Okay. Miss Heard's tweet linking. Here we go. We're talking about the tweet. Miss Heard links tweet more. Have you been on live stream too long? Probably, Miss Heard twink. Okay. Miss Heard's tweet linking the newspaper article does not constitute republication under applicable law and the facts. Virginia follows the single publication rule under which the mass distribution of defamatory communications such as internet posts are not deemed to be republished each time the communication is reposted or repeated. The public policy supporting the single publication rule and the traditional principle of republication dictate that a mere, let's listen to the language, a mere hyperlink without more, come on, lawyers, cannot constitute republication. Tweeting a link does not constitute republication, even if the tweet includes a mere, look at us, mere reference to the article. Sorry, I'm reading, trying to get through all the citation. Though a link and reference may bring readers' attention to the existence of an article, they do not republish the article. Okay. Rather, republication requires editing and transmitting the defamatory material or redistributing the material with the goal of reaching a new audience. How many Twitter followers does Amber Heard have? That would be the question. And do all of her Twitter followers also read the article? Or did she retweet it because they saw that not enough people read the article straight from the Washington Post? Questions that need answers. What was her purpose of retweeting the article? Stated differently, republication occurs when the speaker has affirmatively reiterated the statement. Initially, Miss Heard never edited or played a role with respect to the headline. Moreover, a brief reference to the linked article, like how they use brief, trying to get close to mere, does not constitute editing the article. Tweet, which merely refers to the article, was not a republication. Mere reference to an article. Listen, we're saying mere, that means small, okay? Regardless how favorable it is, as long as it does not restate the defamatory material, does not republish the material. Although Miss Heard's tweets called attention to the article, minimizing her efforts, and indicated she was the author. Amber Heard's tweet indicated that Amber was the author. I've never seen the tweet. I'm gonna have to find the tweet. Okay. The tweet did not edit or add content to the article in a manner sufficient to overcome Virginia's single publication rule. Miss Heard also never redistributed the headline statement with the goal of reaching a new audience. Tweeting a link to a prominent global newspaper article does not redistribute material to a new audience as a matter of law. Okay, that's a law. That sounds like a sufficient law there. Okay, the hyperlink served as a reference to the New York Times existing audience. How do you know who already followed the New York Times? Okay. It did not redirect the old article to the new audience. Okay. The 2020 tweet about the 2019 article served as reference for Reuters' existence audience. not a new audience, and third-party tweets at issue did not constitute republication. And so I'm not seeing them really explain the case on this one, but I'm going to assume, just like she referred it to or compared it to the teacher, this is a situation of the same thing. Okay. They keep saying the same thing over and over. Okay. In short, Ms. Heard never affirmatively reiterated the headline as required for republication under the law and facts. Republication occurs when a speaker has affirmatively, that just restates, the mere link and brief reference to an online article in a global newspaper is insufficient to constitute affirmative reiteration. She just took a bunch of cases and slapped on like parts, like little pieces out of the cases. Okay. Moreover, no evidence reasonably supporting a finding that Ms. Heard republished the headline by tweeting the link to a global newspaper article. Ms. Heard had no control over whether her link to the newspaper article included the article's headline. Really? She had no authority over that. I want to find the tweet now. Okay. Moving on, Mr. Depp did not present evidence of actual malice. Okay, a public figure may not recover damages without proving actual malice. To establish actual malice, the plaintiff must demonstrate the defendant realized that his statement was false or that he subjectively entertained serious doubts. Those are just rules. Proof of actual malice. In this case, proving actual malice required showing that at the time the op-ed was published, Ms. Heard did not believe she was abused or that she entertained serious doubts. We know that she thought she was abused, but the jury didn't believe her. That's the thing. The jury didn't believe her. They didn't believe that she thought it. Just because Amber Heard believed it doesn't mean the jury believes that she believed it. Okay. Further, because actual malice is a subjective standard, whether Ms. Heard believes she was abused must be judged by her definition of abuse. And that is what I stuck to throughout this case. I said that depending on what kind of abuse she's alleging, Johnny Depp could be found to have abused her. And so they're saying they should base it on her definition of abuse, but not necessarily on the definition of abuse, which is true. She probably did believe that she was abused, but did the jury believe that she believed that she was? Because we have to give credibility, right? And it sounds like the jury didn't believe that she actually believed it, especially with the testimony that she basically manipulated one of the mental illness tests, right? The mental state test. I forget what test it was, but she basically manipulated the test. And so do you think that she cannot manipulate that she felt that way? Who knows? I might just be against Amber. Okay. Further, let me go back to the article. Further, because actual malice is a subjective standard, her definition of abuse. Okay. Ms. Heard testified unequivocally that Mr. Depp abused her physically, emotionally, and psychologically, but they didn't believe her. Okay. Mr. Depp presented no evidence that Ms. Heard did not believe abuse can be physical, emotional, or psychological. He didn't have to present evidence of that. They just presented evidence that she actually abused him. So there's no way that she can believe that she's an abuse victim and not also consider Johnny Depp to be an abuse victim. That's another point. All right. So then they go on to talk about some of the things that she probably considered to be abuse. All right. Sorry, I got emails coming in. Okay. Mr. Depp repeatedly asked Ms. Heard to cut him with a knife and threatened to cut himself. Mr. Depp intimidated Ms. Heard. And so they just go on to list some of the reasons why she would have believed that she was abused. But what about her abusing him? All right. Moreover, while domestic abuse is not limited to physical violence, undisputed evidence also established that Mr. Depp participated in physical fights. That's the wording you want to use. So you are basically acknowledging that Amber Heard is probably the one that started the physical fight. So he participated in a physical fight, which could also mean that he was defending himself. Not the best language. I like it. I like how you tried to slide that there, but I caught it. I caught what you did there. Okay. With Ms. Heard and used force. For example, Mr. Depp admitted that in a recording he had headbutted you in the effing forehead. That doesn't break your nose. Yeah, I guess. Did he say headbutted though? I don't know if he used that word. I don't remember. While Mr. Depp testified that he didn't intentionally headbutt Ms. Heard, it does not follow that Ms. Heard could have concluded he intentionally headbutted her. They are making me so angry. I'm so happy that we're almost done with this document because they're making me mad. Because she believed that he intentionally headbutted her. So he's abusive, but he was trying to restrain her from attacking him. Okay. All right. So she also could have believed that Mr. Depp headbutting her was abusive, regardless of whether it was intentional. In other words, Mr. Depp presented no evidence that Ms. Heard did not believe that his headbutt was physically abusive. He didn't have to. The thing is, he did not have to present that evidence. The jury made that inference from what she said and what she did to him. He presented evidence that she was an abuser. So how could she believe that she was abused if she was the abuser? I don't know. In another recording, Mr. Depp said, "I left last night. Honestly, I swear to you, because I just couldn't take the idea of more physicality, more physical abuse on each other." This recording shows at minimum that Mr. Depp believed the party conduct could be interpreted as physical abuse of each other. But I thought the article wasn't about him, so what does it matter? If the article wasn't about him, what does it matter if he did abuse her or not? Because the article was about him, right? Okay. Or that he believes that Ms. Heard's view their conduct as physical abuse to each other. Either conclusion supports Ms. Heard's belief that Mr. Depp physically abused her, and Mr. Depp adduced no evidence to the contrary. Johnny Depp did produce evidence that she was starting physical altercations with him and that he would run from her. And when he couldn't run from her, he maybe restrained her. As he's restraining her, he accidentally headbutted her. All of those things are evidence that he does not think that he is abusing her. I ran away from you. I did not throw this thing. Whatever he said, those can count as evidence that he was not the abuser. So again, the misstatement, and I know you have to plead facts most favorable to your client, but these are reaches for me. These are reaches. Because Mr. Depp presented no evidence that Ms. Heard did not believe he abused her physically, emotionally, and psychology, he failed to prove actual malice, and the verdict must be set aside. He does not have to say it is actual malice because that's what it seems like her attorneys wanted him to do. This is actual malice because she did not really believe that she was abused. He presented evidence to say she did not believe that she was really abused. She was not really afraid of me because look how she confronted me in the kitchen. Look how she argued with me. Look how she told me to stay there when we're arguing. Look how she gifted me a knife. Those are evidence that she knew that she was not abused. I'm sorry. You don't have to come out straight and say, she did not believe she was abused. Like, you don't have to say that. You just present your evidence and the jury infers. Okay. Mr. Depp did not present sufficient evidence to support a finding of defamation by innuendo. When a plaintiff claims that he was defamed by statements that are literally true because of false implication arising from them, the implication must reasonably be drawn from the word's actual use. In such cases, the plaintiff may prove defamation through innuendo, an explanation of the alleged defamatory meaning of the statement if it is not apparent on the face. All right. No evidence surrounding the op-ed publication would reasonably cause a reader to believe that the title of the online edition was about Mr. Depp. Do we really need to go through this? Do we really need to go through this? She says that it's not about him and then turns around and say, well, he did abuse me. He was my partner that abused me, but it wasn't about him. It's very contradictory. It's very contradictory. How could you say there's no evidence and then come and present evidence why you think he's abusive? That he was actually abusive. I don't even want to go through this. Okay? Okay. Let's see what she even has to say. Okay, let me see. Let's get past the cases. During the opening statements, counsel for Mr. Depp forecasted that with respect to the title, he would present no evidence of circumstances surrounding publication of the op-ed that would suggest that the title was about Mr. Depp. Okay. In other words, Mr. Depp's theory was that allegations of SA made after the op-ed's publication and after the commencement of the instant action caused readers to understand the title to be about Mr. Depp. This theory finds no support in any authority and is contrary to Virginia law, which requires plaintiff to prove the circumstances surrounding the statements caused to be in part a defamatory implication. Consistent with counsel's opening statement at trial, Mr. Depp presented no evidence that prior to shortly after the op-ed's publication, Ms. Heard accused him of SA. The only evidence of prior allegations of SA was Ms. Heard's testimony in the United Kingdom. She was provided with confidentiality when testifying incidents of SA. But then you also presented evidence of SA here. If you're referring to the abuse being by him, you can also infer that the SA is also about him. I don't know. I don't know if I like it. I don't know if I like it. Okay, let's see what. Okay, so basically just trying to say that there were no statements to prove that she said the essay was about him. No evidence established contemporaneous facts surrounding the publication of the op-ed and would reasonably cause a reader to understand any of the statement as conveying a defamatory implication about Depp. Again, I am probably going to skip this one because you can't sit there and say that and then present evidence. I mean, you can, but it doesn't make sense for you to say, oh, it's not about him, but he did abuse me. He did do these things to me. But it wasn't about him. It's counterproductive. Okay. Mr. Depp cannot recover the statements Ms. Heard made during judicial proceedings, and he failed to prove that any statement in the op-ed implies he abused Ms. Heard. Okay. We're going to skip that. Because I feel like I'm a broken record at this point of that he did present evidence that he inferred it was about him because of the time frame in which she said 2 years ago this happened to me, and then 2 years ago she filed the DVTRO, but then she doesn't want him to mention the DVTRO because she referred to 2 years ago as when she survived the domestic violence. And so I'm not getting what she's getting at this point. Okay, let's get into the juror misconduct. Let me see what some of the peeps are saying real quick because I've been seeing some chats come in and I am behind. I'm very much behind. As Lee says, Johnny is minding his business, working overseas, and Elaine and Amber Heard are out here acting a fool. It basically is what's happening. Tanya says, right. Tanya says, he left us to deal with the foolishness. He had enough. Like I said, I wouldn't even fight the appeal at this point. She has already put herself out there. Even if she can win on an appeal, I still don't think she can ever vindicate herself. She's always going to be just a mess in my eyes. All right. Esley says, I know he owes us something great because we're dealing with it, right? Tanya D says, but she's a public figure, right? Doesn't that mean new people would see it, especially since her big movie was coming out? Exactly. Like I said, she referenced a case, and I didn't read into the case, and she didn't really cite the lines that were supporting the facts of her case, but I'm assuming And this is just my assumption that it's going to be similar to her comparing it to those teacher stories of like, it's completely different situations. You can't compare apples and oranges, right? So to retweet it as a public figure, as people with a lot of followers, you don't know who actually follows the New York Post or whoever the Post is she's claiming. You don't know who follows them and who follows you. You're most likely going to have some followers that's not following that news outlet. So I would say it did go to a new audience. Okay. Deacon Fatal says, ugh, this me being frustration as all get out. When I say ugh, I'm like, what the hell are you thinking? Yeah, that's where I'm at this point. As Lee says, Elaine, this is not Amber Heard's world, right? Deacon Fatal says, I do think she was abused because, again, both are kind of poo. The thing is, I'm not on that jury and I'm not a doctor and I'm an adjudicator, Jim. I think I don't know if that this is. I think that is a lie. Yeah. So for me, I can see how he could be an abuser. And like I've said on several other streams, I understand people don't like the terms mutual abuse, but that does exist. Even if he was verbally abusive to her and then they did get in a physical altercation and he does restrain her, could be considered self-defense, could be considered he intentionally headbutted her like he's claiming. It's very hard when you're getting into those physical situations to really determine who's at fault. And then you're staying in a relationship with that person. And maybe, let's say she beats him up 10 times, as an example. She beats him up 10 times. He reacts one time and he hits her. All of a sudden, he's now an abuser as well. Reactive abuse, right? So either way, they both come off to me as toxic. Whether his be the emotional and verbal stuff, the yelling, because surprise, surprise, yelling and all of that stuff does count as abuse in some states. Disturbing the peace is what they call it, making you uncomfortable, things like that. So I do think that they were definitely in a toxic relationship, in my opinion. But I definitely see what you're saying about they're both kind of poo. They're both a little responsible, right? All right. Deacon says thinks that she is lying. Tiny D says, I think she seriously thought she was abused, but she exaggerates them. Like she said, you're killing me and you're pushing me when he wanted to go see his daughter. Yes, 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 exactly. She's also very manipulative. So, of course, in her head and with her diagnosis, she does most likely believe it. But her exaggerations, especially on the stand, the jury just probably doesn't believe that she believed it. And I don't think that's unreasonable for them to do. Okay. Deacon Vado says, that being said, I can also same reactionary abuse. Yeah, exactly. Reactionary abuse or mutual abuse, different places use different terms. Dasby says she stay reaching. They do. Deacon says again, she doesn't know how to make her case. Yeah, I think they're just very contradictory at this point. I do want to get into what they're talking about with the jury verdict. So let's pop over. It's not as long as some of the other stuff. So we're going to pop over there in just a second. Jennifer says this might be the worst argument yet. Yeah, they save the bad stuff for at the bottom of the paper when the judge is too tired to read it, right? Okay, let's see. Document here. The court should conduct an investigation. This is about our juror that was supposed to be from 1945, okay? They should conduct the investigation of juror number 15 and whether jury service was proper and due process was protected. The court should investigate whether juror 15 properly served on the jury. On the juror panel list sent to counsel before I can't say these words. Okay, the court noted that the individual who would later be designated as juror 15 had a birth year of 1945. Juror 15, however, was clearly born later than 1945, publicly available information demonstrates that it's a guy, he appears to have been born in 1970. So they went and looked up his public information, probably went and looked him up on Facebook or something. This discrepancy raises the question whether Juror 15 actually received a summons for jury duty and was properly vetted by the court to serve on the jury. Right, because are they using people from that age group on a jury? I don't know the age limits. At the time of assembly, for the purpose of juror selection, the identity of each member of the jury veneer should or shall be verified as provided in this section. Prior to being selected from the jury veneer, a potential juror shall verify his identity by presenting to the person taking jury attendance any of the following forms of identification: his Commonwealth of Virginia voter registration card, his Social Security card, his valid Virginia license, all these other things, and a valid employee identification card containing a photograph of the juror and issued by an employer of the juror in the ordinary course of employment business. If the juror is unable to present one of these forms of identification, he shall sign a statement affirming under penalty of perjury that he is the named juror. Thus, the court's clerk office had a statutory obligation to verify the identity of Juror 15. But because Juror 15 was not born in 1945, it appears his identity could not have been verified through any of the means of identification the code provides. And it also raises questions about whether or how Juror 15 could have signed a statement affirming under penalty of perjury that he was the named juror if he was 25 years younger than the person the court recognized as Juror 15. Shout out to the person that did the 25-year math. Oh, I think I did it a little bit. Did I? Yeah, I did. So shout out to me and the other people in the chat. Although the Virginia Supreme Court has previously construed the VA code requiring the jury panel to be available at least 24 hours before a trial to be directory rather than mandatory, it is observed that attendance to the provision is required to the extent necessary to ensure due process. It therefore follows that adherence to this section is necessary to ensure due process, even if it is viewed as a directory rather than a mandatory statute. So I'm wondering if like someone just filled in for their grandpa, or not their grandpa, their dad or their mom. That would be funny. But that would make a retrial, so no, it wouldn't be funny. Okay. To the extent that the individual who served as Juror 15 was not, in fact, the same individual on the veneer, I cannot say that word to save my life, or the court clerk's office did not verify his identity, Ms. Heard's due process was compromised. The Virginia Code does not contemplate jury service by someone not on the veneer. I'm going to just call it veneer. For a good reason. In any case, but especially a high-profile case such as this one, it is critical to ensure no person who is not on the veneer, I keep changing it, is able to serve on the jury, whether by inadvertence or intention. Here, the facts show Juror 15 was decades younger than the individual on the jury panel list, raising questions as to whether they were the same or different people. Ms. Heard therefore requests that the court investigate whether Juror 15 was properly part of the veneer and whether prior jury service, Juror 15 verified his information in a manner prescribed. Ms. Heard further requests the court to take appropriate action based on the results of the investigation. If appropriate, ordering a new trial. She wants to go to trial again. She liked the attention. Okay. Conclusion. For all the reasons set forth above, for the reasons set forth in the record during the hearing and the trial, in the motions eliminate and motions to strike, Ms. Heard respectfully requests this court to set aside the jury verdict in favor of Mr. Depp and against Mr. Heard in its entirety, dismiss the complaint, or in the alternative, order a new trial. Ms. Heard further requests this court to investigate potential improper juror service and take appropriate action warranted by the results of the investigation. And that is the end of our document. We made it through. Okay. What do you guys think? This is Amber Heard's attempt at a new trial. New trial. What do you guys think? Okay. We have, you guys are talking. Deacon Fatal says, no, we don't unless you want to continue. I'm good. Okay. Bobby Griffith said she admitted in court it was about him. Yes, she did. So it's very counterproductive. Sorry for the talking. I've been talking for 2.5 hours. That's ridiculous. I should not do that. Des Beat says Amber needs to fire her lawyers. These claims are worse than the first time around. Yeah. I mean, but they have to argue what they have. I would say have, but to me, they don't have it. But if their client is pushing and they're throwing money at them, they just kind of have to do it. I think it's embarrassing to their firm. Tanya D says, talk to someone with real bipolar depression. Is that bipolar depression or borderline personality disorder? I think. Yeah, borderline personality disorder. And that's how they talk. Everything is a contradiction to the previous statement. Well, maybe Elaine needs to go get a diagnosis, because that's who's writing this. Elaine Bredehoff is signed by her. Yep. Let me show you. Respectfully submitted, Elaine. Elaine Bredehoff. So very contradictory. Okay. Deacon Fatal says, again, I'm poor and have no idea what rich folks go through. That is another thing. We are just judging from the sidelines. For sure. Okay. We have Dasby says, Mr. Depp presented mad evidence, laughing my A off. Yes. But they wanted them to specifically say, this is why she did not believe that she was abused. You don't have to do that. Okay, Deacon Fatal, I'm going to be honest. It's hard for me to care when I know both parties can afford therapy and they need, never mind. Let me not say that. Maybe they should go. Lindian says, the judge Ascarati have to respond to every ridiculous item seems like such a waste of valuable time. If you remember, even in the trials, they get it beforehand. So they don't necessarily need to address every single thing that she put in there. And if you guys notice, most of the things that she put in there was just a bunch of statements of law or statements of rule. She didn't really give too much factual analysis in there. So she can just address it very shortly. She doesn't have to go super deep into it if she doesn't want to. Okay. We have Kath saying, honestly, it's also confusing. Are they trying to confuse the judge? They're confusing us, right? How can it help her case? As for Elaine, is she trying to burn bridges with the court and the jurors, or is she in this case too deep? I feel like she's connected to Amber at this point, because like I said, it's Tanya said the contradictory statements that goes with the diagnosis that Amber has, but Elaine is the one writing this, unless she's letting Amber write it and they just edit it. I don't know, but I think she's in too deep. I think they're in too deep. I think Amber's in too deep. Dad says they both have issues. They both do have issues, but at this point, I feel like Amber might have more issues because she's still going on with this nonsense. She even fought this nonsense. Sabrina says, Kent Stay just wanted to pop in and say hi to the high. Well, hello. Thank you for popping in. Hope you hit the like button on the way in. Okay, McGuffey says, Amber was definitely more abusive, but if I walked into the kitchen and my drunk spouse was knocking my kitchen cabinets off and breaking stuff, I'd consider that abusive. And it could be considered abusive by a court. It definitely can. And people don't like to hear that, especially the people with the most testosterone, the men. They don't like to hear that because they feel like, or let me not say they feel like, I've gotten some comments that they some men feel like they should be able to raise their voice, and if they slam a cabinet, it's better than punching you in the face. things like that. But a court does not care if you were punching the cabinet or you're punching the face. You can still be considered as an abuser at that point. Okay. Where am I at? Where'd it go? Okay. Amber was definitely, oh, that was the one I just read. Okay, Tiny D says, okay, Bri and chat headed to the movies. Oh, I hope you have a good time at the movies. Thank you for chatting with us and stopping by. I know it went a little bit longer today than I was planning on going. Okay, S. Lee says, it was the day after his mom died and the day he found out his agent sold 50 million from him. And that's talking about the slamming of the cabinets and whether it's considered abusive or not. But to me, she clearly was not afraid of him because she approached him and she recorded him in the moment and then allegedly sent the video to TMZ. Okay. Cass says, there are a few instances that I believe that JD may be abusive in her mind, for example, for her career. I think she believed that he was holding her back, but in his mind, he was helping her. I definitely agree with you. Some things, the thing is, people can think it's abuse. And that's why I said, okay, depending on what type of abuse, people can find that he's been abusive. And so I don't doubt that she truly believed that she was being abused. But when you put in the factors of you appearing to be lying on the stand, you appearing to be disingenuous on the stand, you appearing to be disingenuous just in your emotions in the court, and on top of that, you being accused of also abusing the other person, it makes the juror less inclined to believe that she believed that. But after seeing her and knowing what type of personality disorder that she might have, she might have actually believed that. But a juror may have considered, okay, but would I believe that I was being abused if this happened to me? Are they supposed to do that? No. But can we stop them from doing that? No, because they're in the juror room without us, right? All right. Deacon Vado says, because you be a juror, you have to have that, I would think. Yeah, you would have to identify yourself. So I get objecting to that, but I don't get waiting till the end of the trial. Well, I guess they didn't want to look up the jurors during the trial because this sounds like they said public information. It sounds like they looked them up on Facebook, right? They're probably like, oh, that guy was looking young. He must have been using Amica cream. Let's look him up on Facebook. Oh, that one of the junior associates look him up, right? Deacon Fatal says, yeah, because you be a juror, you have to have, oh yeah, okay, I already read that one. That's why. All right. Deacon Fatal says 1945. Yep, that would make that person, I don't even know how old. I can't do that math in my head. That would make you 55 in 2000 plus 20, 75, make you 77. I think someone already put that in the chat. All right. S. Lee said this questioned the juror and saw him for weeks. Yeah, they just waited for it. Maybe they didn't want to do outside research as well. All right, we got Hella Slinky says, don't forget to do the YouTube things, like, subscribe, and hit the bell, and join the membership if you can, for sure. Thank you, Hella Slinky. I've been missing some of your comments here. People teaching me how to speak on my live streams. Jennifer says, Bawa dear. Yeah, I'm not going to remember that. Cal says, again, all I'm asking is how. The court missed it. The judge missed it. Amber Heard and Johnny Team missed it. The audience and some of them watched every day, like James from court missed it. The thing is, they probably didn't. The outside people probably didn't have like the demographics of the people, like their age and stuff. So it will be more that the judge and other people missed it. And maybe the person just looked young for their age. Maybe. I don't know. But like someone said, maybe it's the guy that was rolling his eyes. And so they wanted to find something wrong with him. Okay, Deacon says, if there is going to be a movie, it might be because, can we have it black and white old school? I mean, if we are going to be silly. As far as this trial, I would not watch that movie. It's just Amber Heard actors looking sad. McGuffers, I'm sticking to my previous statement. They want to redo so they can do Rottenborn's way. Because those were the arguments that Rottenborn was making from the beginning. And I don't know if Rottenborn is going to want to stick on this. It was too much of a mess. In my opinion, too much of a mess. Hello Swanky says, to become a member, hit the join button on the desktop or Android device to get perks for supporting the channel. Yes, exactly. Thank you. Thank you for the shout out. Deacon Fatal says, I hate it. The case. Lindy N says, it seems unreasonable to expect someone in their 70s to sit through all that boring long testimony and not fall asleep or have some medical restriction to get in the way. And maybe that's why they wanted a 70-year-old and now they're having a problem that it's more like a 50-year-old, right? Esley said, I wish I could see Judge A. I know she was irritated. As soon as this hit her desk, she was like, I'm going on vacation. That's what I would be like. Kat says, congratulations, we're done. Yes, we made it through the end. And we went through a lot of it. We went through a lot of it. So you guys can have a good opinion of what her arguments are. My cat's an a-hole. I think Elaine's cat wrote the motion. Looks like something my cat would do. That's funny. Yeah, someone wrote this. Elaine. Elaine and her cat together, maybe. Deacon Feta says, well, is she telling her lawyers the truth? I have my opinions on that. I don't think that she tells her lawyers the truth. I think she tells her lawyers the stories that she believes in her brain. And I think that you can tell in the way that Elaine asked questions during the trial. She was asking questions. A lot of times when lawyers ask questions, you are expecting a certain answer because your client has already told you the gist of what's going on. And in the depositions, Elaine will ask a question, or even on cross, or not cross, direct and cross. Elaine will ask a question, and when the answer comes back as something she didn't like, she'll reword the question and ask it again and get the same answer, which makes it seem like she was expecting another answer. Could just be her strategy, but to me, it came off as, my next question is something completely different because I was expecting a different answer. That's what it comes off as to me. Betsy says Elaine. Dasby says the juror thing is her strongest claim for retrial. I think so too. I think the juror thing is the strongest thing. Lindian says someone in their late 70s, exactly, 77. Unless they're in like good health, they might be walking a little slower. A lot of things could have told that this person was 77. Hello Swinker says, hey yo, gotta head out. Sorta gonna be watching, but I'll have to lurk as I'll be driving. Don't want to be typing so much. So in case I don't get to say bye, see y'all Tuesday. Yes, exactly. Thank you so much for joining. Happy that you can still stay on. We are going to be wrapping up in just a moment. I'm just trying to get through some more of the chats, and then I gotta figure out what I'm having for dinner. Okay, I'm going late today. Okay, Deacon Fatal says that no one asked for as far as this case. Deacon Fatal says, I have watched that movie again. And what if she's still playing that character? I'm not sure what movie you guys are talking about there. So I just got my alert through the door. So I got to wrap up here. Deacon Fatal says, have to agree. Okay, and we have a super chat from End Our Silence. Thank you so much for supporting the channel with a super chat. End in Our Silence says, showed up late, first time as a survivor. Her story is a joke and not a funny one. Just started a channel as a survivor because stories like this boil my blood. Well, thank you so much for joining into the live stream. I think a lot of people are in agreement with you as far as her story just really not being believable and being considered a joke. And so you guys, go ahead and check out Ending Our Silence story or Ending Our Silence channel because they started a channel to talk about things like this. So thank you so much for the super chat. Sorry, got a bit distracted. What's up? We got Alpha coming in. I'm almost done here. All right. So yeah, guys, make sure to check out Ending Our Silent. Check out the stories. Check out the stories that they have going on over there. All right. So Jennifer Miller says, thank you so much for supporting. Thank you. Exactly. Thank you so much for supporting with the super chat for sure. And if you guys are unable to give super chats and you want to support for free, go ahead and hit the thumbs up button if you have not already. Also hit the subscribe button. cost you nothing, just a little bit of effort to push some buttons, right? And also you can watch the ads. Okay, we got Deacon Fatal saying I would have fell asleep now. Well, we got the judge needing to go through this. Okay, I got a couple of more and then we're gonna pop off of here. Okay, Kath says true with the career thing. It disappeared. Okay, with the career thing, I just felt that frustration in her that I couldn't get from when she was talking about her essay allegations, which is odd. I'd expect the essay would bring more anger in her. Yeah, and it just all felt like acting to me. Her story felt like complete acting to me. McGovern says, haha, my cat just woke up for my cat and a-hole. Hello. We have McGovern says, I think Elaine took this personally because of how badly she was made fun of on the social media and is trying to recoup her reputation. She's doing it the wrong way, but I think Elaine should just retire. She did a good job. I mean, she worked with what she had, the facts that she had, she worked with them, but she should retire. She seems like she's been an attorney for a while, so do your severance package. Don't keep doing this case for Amber Heard, in my opinion, right? As Lee says, but if they were interviewed and met the requirements, why a new trial? Because they're basically saying that this person did not verify their identity to prove that they were the person born in 1945. So let's say that someone got a summons in the mail and they either no longer live there, or it was like, let's say it was someone's dad and they had the same name. And so when he got the jury's summons, he went, and let's say he's a junior, but they didn't put junior or senior on the paper. And he went and he was born in 1970, but he has the same name. They're basically saying that they never looked at his ID to confirm it was the 1945 person. But at the same time, they said one of the ways that they can prove their identity is a social security card, which doesn't have their birthday on it unless they're going to go look up their birthday from their social security number. Another way that they could prove their identity is an employer card with your picture on it, which doesn't necessarily mean that it's going to have your birthday on it. So if that person just had the same name, they could have verified it. They just didn't verify the actual birthday. So depending on what the deeper rules are as far as like proving the actual date that you were born, they could have very well just had the same name as someone that lived in their house or used to live in their house. I don't know what the facts are. We'll see when the response comes out, but that could happen. Because they could have verified and it just wasn't the verification that Elaine was expecting, right? Sage Moon says, thank you, Bri. Thank you, Bri Hive. Love the Bri Hive party. Always the best vibes and laugh from this community. Buzz on by the like, subscribe, and join button to help your girl get to 8K. Yes, thank you so much, Sage Moon. Definitely appreciate that. We have ended our silence with the $10 super chat. Again, thank you so much for supporting the channel. Saying thank you for the shout out. I will be following you. Well, yes, thank you. If you're not subscribed, go ahead and subscribe. And if you guys are not subscribed to Ending Our Silence, go ahead and subscribe to the channel. Sounds like they're going to have some good information and good stories over there for us to learn from. So check them out. They're supporting the channel. So let's support their channel. All right, we have Jennifer Miller saying like, subscribe, and join to support Bri. Thank you for being here. Yes, exactly. We are wrapping up here. Let me get this one last question here. Random question from Kath saying, if Elaine retires, does it automatically mean her name is going to be removed in the name of the law firm? Not exactly. She could still be a partner depending on their local rules. Like for California, you can't be a partner in a law firm if you are not actually a lawyer. Since she's a retired lawyer, she could still be named on the partnership. It will just depend on their laws and the rules of their firm if they want to keep it on there. It looks like she's the second name listed. So as a founder, she's probably going to continue to be listed. So no, they don't have to remove her name automatically. Okay, so That is all for the live stream today. Thank you guys for bearing with me. This was a long one, almost 3 hours, today. A shout out to Alpha because he worked late, which allowed me to stay on here later with you. And we were able to cover a lot more of the content. So thank you everyone for joining me. I hope to see you on the next live stream. If you have not already, please hit the like button, the subscribe button, the join button if you can, and the notification bell so that you can be notified anytime I go live. Thank you guys so much for joining me, and I will see you on the next stream.